7th July 2025, we are proceeding with the matter of Mengo and Mbenenge. Mr. Sikakani.
Thank you, Chair. It appears that there is some remnants of previous evidence that Mr. Madonsela and the evidence leader want to deal with before I call my witness. Thanks.
Mr. Madonsela.
Chair, we would like to, by agreement, dispense with the evidence of one witness, Captain Botha, and his evidence to be found at volume 1, page 438 to 459. 459. What we wish to place on record by consent is that the evidence of Captain Malcolm Greg Botha, contained in his report on mobile phone analysis under Cambridge CAS 175/12 /2023 is to be admitted. Without the need of calling Captain Botha. Thank you, Chair.
Advocate Skipper.
Thank you, Chair. It is in agreement that we can deal with the evidence of Captain Botha on the report as contained on pages 438 to 459 without calling him, without the need of calling him as a witness.
Advocate Patlander.
Thank you, Chair. I'm not sure whether I have any say in this, but to the extent that we do, we agree that the report of Captain Botha on the pages that the evidence leader has indicated may be admitted.
Okay, all right. Thank you.
Chair, I should say before Madeleine Friend comes in that there are what Madeleine Friend calls remnant of evidence that I was supposed to lead, particularly with reference to the court manager, Mr. Mhlonhlo, which are still looming large in the background and will be resolved after the evidence of the respondent.
All right. Thank you. Yes, Mr. Sikakani.
Thank you, Chair. May I call my next witness, which is Judge President President Selby Mbenenge.
Is there, sorry, is there a file we should take out?
Yeah, yes.
Or not
Chair.
yet?
I was going to take it through once we're done, but yes.
Judge President, may we have your full names, please?
Good morning, everybody. I'm Selby Mbenenge.
You have an objection against taking an oath?
Not at all.
In which case, do you say that the evidence you are about to give will be nothing else but the truth? And if so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. Before I address my questions to the respondent, the JP, may I indicate that there is a file that is placed before the panel. It's not anything new. It's a file so that it's convenient. It does make reference to the specific pages in the record, in the volume. It's just that it's the sequence of his own testimony. And so it's not a file with new documents at all. And so you could keep it there just for his own reference, for his own sequence. Secondly, Chair and members of the tribunal, let me indicate before I start that I'm going to deal with 4 themes. The first theme is going to be just a theme about, it will become relevant. It's about himself and who he is. That's the first thing. And that would cover just his career and this complaint. The second theme is going to be the issue that is right at the heart of this, or one of them, which is the incident, the so-called incident of the 14th or 15th of November. And the third is another one which has become an issue, which is the picture that the respondent, JP, is alleged to have sent. It's K8. We've been dealing with it as K8. The last big theme that we're going to talk about is the chats themselves. The sub-themes of which are the general flirtatious chats, and that's common cause. And the second sub-theme in that theme is the complainant's own flirtatious chats. And this will be found in volume 1 that we've always had. And so the files that are going to be important largely in this testimony is volume 1, volume 3, and you'll be taken through that using the file that's been given to you with references. Thank you, Chair. May I start?
Yes, please.
Judge President, if we can start with who you are, your career briefly, and I'm not going to ask you about your character because we know now we're not going to deal with character, but just who you are, your history, becoming a judge president.
Thank you, Counsel. I was born in Butterworth. I did my primary education there, and then I moved to Umtata when my parents moved to Umtata. I studied at the University of Transkei, 2 degrees, firstly B Juris and thereafter LLB. Before being an advocate, it was a bit of a winding road, if I may put it like that. I was a prosecutor at some point. I was a state law advisor. I was a lecturer. I then joined the bar after undergoing pupillage at the Joburg Bar. I became an advocate for 22 years, 11 years as junior counsel and 11 years as senior counsel. I became a judge on 1 July 2015. And then in 2017, around May, I became ADJP in Umtata. The post of JP fell vacant. There was the first bout of interviews that were conducted. 4 of my colleagues were nominated. That process yielded nothing in the sense that no recommendation was made by the JSC. I availed myself. I became JP after undergoing the usual interview. I became JP on 1 November 2017, if I remember well. So basically, that is my pathway to being JP from the academic side of things and from the professional side of things.
Could you just tell the tribunal briefly about challenges that you may have faced by becoming a JP, judge president of a province, just after 2 years as a judge?
Maybe before I deal with that, Council, I hope it won't derail you. One of the documents that I will be referring to at page 10 of the consolidated bundle that I believe has been availed to everyone concerned. One will see that there is reference to Form 2. It says it is alleged that the facts set out in Annexure A to this notice constitute a complaint of incapacity, gross incompetence, or gross misconduct against you. In other words, it is as broad as all that. And one is not sure exactly why there is reference to incompetence and incapacity. But to the extent that there is maybe an allegation about incompetence, I can only refer to my CV, reported cases that were penned by me, and so on and so forth. But I don't want this tribunal to be carried away when it comes to that. It suffices basically to say, as counsel, I have to my favor 48 reported judgments. I'm not talking about judgments in Safely, I'm just talking about reported judgments. You will see that the last of those, number 48 at page 5, is Poswa versus President of the RSA. And then as acting judge, when I was acting from time to time, I have 9 judgments, and I have made reference to some other authorities where those judgments are referred to. And then as a judge, I have accumulated, I'm just saying as a judge, I've accumulated 13 reported judgments. And as JP, I have accumulated 6 judgments. That is those that are reported. There may be reference to some in the course of what I will be saying, to the extent that, as I have said, mention has been made of some incompetence. I don't know in what context. There are publications that I point to at page 9. Transformative Constitutionalism, a Judicial Perspective from the Eastern Cape. It's published in the University of Fort Hare Law Journal. And then the other one, A Dead Horse Need Not Be Flogged, The Duty Not to Pursue Unmeritorious Causes, South African Judicial Education Journal, Volume 1, first issue 2018.
JP, can you pause a little bit? You're referring to a document. Which document is that?
Can we go to the bundle?
Bundle? Page?
Bundle, let's go to the bundle. Page 3. This is the consolidated bundle.
From page 2 of what is before us is the complaint itself. Are you referring to that?
No. This is the bundle that I believe was submitted to the panel this morning. It is under index further supplementary bundle for use during respondent's testimony. Has the chairperson found that? The numbering is twofold. There's numbering for the particular bundle, and then on the right-hand side to the general bundle or index. Has the chairperson located the index further supplementary bundle for use during respondent's testimony?
Yes, it's that one, Chair.
Correct. And then, so should I follow the small pagination?
Yes, there's the small numbering. You will see, Chairperson, that page 1 is the CV. Page 1 is the CV.
Yes.
I've mentioned something about the chairperson.
Yes.
And then page 3 are reported cases since I joined the bar. There are let me say there are 48 of them that I could
Yes.
pick up.
Correct.
I don't want to delve into that.
Yeah.
I'm here as a judge otherwise. And then as acting judge, because from time to time I acted as a judge, you will see that there are 9 reported judgments.
On page, smaller page.
Small page is 5, 6, and 7.
Yes.
And then as a judge, starting with Gongose up until S versus Jolingana, 13 reported judgments that I could pick up. And then as a judge president, there are 6 reported judgments at page 8. I've highlighted some of those because in the course of my testimony, I may refer to some of them, but it's just highlighting.
Yeah.
You will see number 10 at page 8, number 2 at the same page, the pages 5 and 6. The last reported judgment is sustaining the Wild Coast, NPC and 8 others versus Minister of Mineral Resources and Energy and 4 others. And then above that is Minister of Police versus Sheriff Mtata. I will say something about that. And then at page 9, these are publications in law journals at my instance that I penned. The first one was published in the Forte Speculum Juris. The second one was published in the Sage Journal. And then the third one was published in the Obiter, which is a law journal of the university or Nelson Mandela University, NMU, Gqeberha. And then the one paper that I read that I thought maybe one should refer to, South African Perspective on the Interplay Between Freedom of Religion and Human Dignity. I read a paper at Brigham Young University in Provo, Utah, United States of America in 2018. So much for that. So much for that, Chairperson. Thank you for your patience.
Yes.
I thought, Councillor, should refer to that insofar as broadly there's mention of incapacity and incompetence. I don't know why.
Yes. Chair, you will see that that is a reference in small page 10 of that bundle. There is some insinuation, in fact, express thing about complaint of incapacity and gross incompetence. And so it's mentioned not to boast about what the respondent has done, but to deal with that kind of accusation. You interposed that, JP, when I was asking you about what challenges did you face on becoming judge president when you had just been a judge for 2 years?
Chairperson, leadership
Judge
in and by
President.
itself is challenging. And I wouldn't love to be seen to be suggesting that there are challenges that beset me, particularly because I had been a judge for 2 years when I became JP. But there are a few peculiar things that I would like to mention that I would like the tribunal to note. These may be situational. It might be that some of them came about during my era as a judge president. The first one has to do with introduction of a judicial case flow management dispensation, a uniform one at that. When I became JP, there was no case flow management in Makhanda, which is Grahamstown. There was something that was done in Bisho and Mtata, but what I championed was introduction of a uniform case flow management dispensation. What I would like to say is that the article that is referred to in the CV, the one about judicial case flow management checkpoint, how far have we gone, which is published in the obiter. The introductory part of it deals with the challenges encountered when CFM or case flow management was introduced. The notion, especially around Grahamstown and those places like Gqeberha and Makanda, the notion that was flying around was, why fix something that is not broken? So from the perspective of some practitioners, the view was that nothing was broken and therefore there was nothing to fix. Yet we know that there are bottlenecks when it comes to the running of cases. Case flow management is meant to ensure that when a matter reaches litis contestatio, if I may put it like that, then it means it should be ensured that when the matter is enrolled, in fact, it runs. Now, to a practitioner who is enthusiastic about postponement of a matter, removal from the roll, fees are marked, and so on, the picture is slightly different. Those tend to frown at judicial case flow management. I'm just stating that purely at the level of it being a challenge. The other challenge that I encountered, and regrettably so, had to do with the media. This may sound a bit controversial. It's not a topic that I intend delving deeply into, but I think it is incumbent on me to demonstrate some aspect in relation to how I picked up a problem with the media. It so happened, or it came to pass in the Eastern Cape, that an order of court was published before it was issued. So I'm saying an order was published by a journalist before the order had been granted by the court. In what circumstances did that happen or take place? That took place in circumstances where a colleague of mine, who is the wife of a journalist, was allocated civil work during the week in question. And then I queried the colleague in circumstances where I was saying, how does it come about for an order to be published in the Daily Dispatch before the order has actually been handed down in a court of law? So this is me talking to a colleague, because the order is published in the Eastern Cape paper, Daily Dispatch. Now, I have annexed to these papers that are serving before you, Chairperson, I have annexed pages 178 to 179, the little 178 to 179. I just wish to refer to this quickly without belaboring the point, but I'm just talking about challenges, Chairperson.
Yes, let us get that page.
Small page 178, otherwise 1508.
Small.
Small on the top there, 178. At the top, the caption there is Eastern Cape mom wins 15 million health claim. by Ray Hartle, 15 July 2020. Then the article itself is at page 179. And then at page 180, we see that on 17 July 2020, there is this order that was granted. Now, there is a publication on the 15th of a court order, and then there is this court order which was granted subsequently. It seems from the report that I received, Chairperson, that even though the draft order had indicated that the order will be granted on a particular day, it ended up not being granted on that day. But then the journalist concerned had sight of the order in the court file. So the issue with me involving the colleague concerned was, my sister, how does it come about for an order to be published before it is issued? This was, in my view, a serious transgression on the part of the member concerned of the bench, but life is not about rushing to the JSC and reporting things. I simply thought that it's a matter that we could discuss and deal with to a finish, which is what we did. But the response of the colleague concerned was, well, my husband does have access to the files. It's not a problem to have access to the files, but the problem is when you publish an order before it is granted. I just want to mention it and leave it at that level. So it is a challenge, Council, coming about purely by reason thereof that one is, or one had become a JP. Ordinarily,
Sorry, I don't understand the statement. My husband has access to the file.
the wife who happens to be my colleague was, well, my husband does have access to the files.
Where? In which way?
Even at home, in the study. Now, I was saying to her, it is not correct for you, my sister, to discuss cases, because the only way your husband could have known that there was this order would have either been you talking between the two of you, or would have been him having access, and the issue is about the publication of an order before it is granted. I hope that answers your question, Chairperson. If I must explain further, I will.
No, I understand. It's just that I find it strange.
Very strange indeed. I then made reference to pillow talk. Pillow talk in the context that then surely, ma'am, you must have discussed this with your husband, because I don't understand how it would come about for him to publish an order before it is granted. Well, we could pack that, nothing became of that. A spirit of reconciliation between me and the colleague concerned had to prevail. But then I need to say something that happened pursuant to that, and I'm going to deal with it with your permission, Chairperson. It is that the next article that was published in the Daily Dispatch by the colleague concerned after I had confronted the wife was a concern expressed that I was not appointing silks, in particular black silks. I think there is an article on this. Let's go, Chairperson, to page 186. Page 186. You will see at page 186, there is my picture there that had been captured. And then the headline is Rao, simmers over appointment of senior counsels. Then it goes on and on to accuse me of not having recommended deserving persons to become silk. So I sought a right of reply, which I was granted by the Daily Dispatch. That is at page 191. It would be to unduly hamper the process in these proceedings for me to read line by line what is contained in the article. It suffices to merely say that I made it demonstrably clear that as soon as I became JP and was approached by my then secretary, telling me that my predecessor had been in the process of considering some applications for silk. Remember, I took office on 1 November 2017. So in January, my secretary brings this, saying to me, there is this outstanding matter, which I had to deal with. So in dealing with that, the matter followed the usual course, chairperson, which I believe is known to you, relating to how people get to be appointed as silks. I made it demonstrably clear that I had never interfered, or I had never delayed, or I had never overlooked the appointment of black silks, particularly in Umtata. So this is what happened thereafter. During a discussion involving me and Mr. Hartle about something else, and I'm now taking the tribunal to page 185. This is a WhatsApp that the journalist concerned dropped me. It dealt with some issue which is not relevant necessarily for present purposes, but can I read it for the record? Finally, I hope that you may also appreciate the extreme offense I took a few years ago when you thought it appropriate to suggest that Belinda and I engage in pillow talk about her work as a judge or ancillary issues. I don't need to read it further. I think for present purposes, it suffices. It makes it clear that he took umbrage in the fact that I confronted his wife, and I don't regret I did. I don't beat about the bush. Very clearly, there was unbecoming conduct. Council, we are dealing with challenges.
Yes.
I will just deal with a few. I don't want to overburden the
Yes.
proceedings, but I think it's important for me to deal with one or two further issues.
By all means.
Oh, sorry, I thought somebody was saying something. One of the challenges then related to a directive on default judgments that I issued. Within legal circles, I think it is known that previously default judgments served in motion court, regardless of whether evidence, oral evidence would be led or not led. So consequent upon the delivery of a judgment by the ACA in a matter, I think it's EFF versus something, that judgment made it clear that claims founded on unliquidated documents should not serve in motion court. The reason is not far to seek. Motion court is a speedy process, and sometimes the proceedings are hamstrung by reason thereof that evidence must be led because the claim is founded on an unliquidated document, or it's an unliquidated claim, so to speak. But may I take the tribunal to page 163. This is a judgment of the full court in Umtata. Page 163. The judgment is actually not a very lengthy one, but I'm just, for present purposes, going to deal with what is set out at page 164. Maybe starting from page 163. Brooks J., who penned the judgment, mentions that on 12 April 2021, the JP issued a directive in the following terms: directions governing the setting down of undefended, unliquidated claims for damages. I'm not going to read the directive itself, but what is very important for present purposes, to the extent that I'm called upon to say something about challenges that beset me as a JP, we go to page 164, paragraph 2 of the judgment. It says the 6 matters before this court are all applications for judgment by default against the Minister of Police, in which unliquidated damages are claimed. Notwithstanding the promulgation of the JP, of the Judge President of the directive 2 weeks earlier, on 28 April 2021, these matters appeared on the roll in a motion court in Umtata, over which the Judge President presided. He issued a composite order in respect thereof and in the following terms. Now, later on, something will be said about a lecture that I delivered relative to default judgment applications. But I'm not dealing with that at the present moment, Chairperson. I'm simply responding to the question posed by counsel in relation to what challenges I encountered. I'm merely demonstrating that you issue a directive. The directive is not necessarily challenged, because if you read the judgment further, it was not challenged. But the issue was, why would practitioners, after a Judge President had issued a directive, believe that they are still entitled to set a matter down in motion court? This is exactly what happened in this instance. I'm just responding to the issue about default judgments as something that became a challenge for me as a JP. And as I've said, I will deal with this in another context at some other point in time.
Sorry, if I may just ask, was that matter then entertained?
The full court,
even though the claim was unliquidated?
yes. So those matters served before me. I did motion court in Umtata on that day, notwithstanding the fact that I had issued a directive. Practitioners, for some or other reason, maybe one will read the judgment and see why they thought they could still do that. Those matters served in motion court, notwithstanding the fact that I had issued a directive. I trust that allays the concern of the chairperson, or it answers the question which has been raised. The point of substance is simply that I issued a directive based on authority handed down by the Supreme Court of Appeal, and that directive was pointing those cases to another court which I had created specially for practitioners. But I'm saying, notwithstanding the fact that I had issued a directive, there are practitioners setting matters down in motion court. I was in that motion court, and I consolidated those matters, placed them before the full court. The full court dealt with the matter in the manner set out in the judgment that I've referred to. Thank you, Chairperson.
I understand. Thank you.
JP,
Let me then just finish up on the issue of challenges, if counsel doesn't mind. There is also the issue of being perceived as a gatekeeper when you are JP. I must concede and confess that, having been trained as an advocate and became senior counsel and eventually became a judge, one might have had this perception that I belong to the conventional school of thought, in the sense that, as most of us will remember, way back then, practitioners who ascended to the bench were mainly senior counsel. I'm just mentioning that in passing, Chairperson. I may have come from that school of thought, but I learned a lot of lessons, which is that magistrates can act, attorneys can act as judges, junior counsel can act as judges. So the challenge that I had was firstly the perception that I am focusing more on silks which did not find support in real terms. Even when I was approached by representatives of the magistrates society, expressing a view that they don't see magistrates acting, my response was, Mr. X and Mr. Z have acted as judges during my era. So there is this pressure emanating from people believing that they are judge material and that they must be considered for acting appointment. Some of us look at judgeship differently. You are a judge because the constituency that you serve believe that you are judge material, not this thing about people who keep on knocking at a JP's office, believing that they are entitled to act. And this is the story of my life. I don't want to deal with that, Chairperson, but I'm just sharing it. It is a challenge that besets JPs generally from time to time. But the issue of gatekeeping becomes relevant to some extent in these proceedings, in the sense that even among colleagues who have got aspirations to serve at the SCA, Concord, Labour Appeal Court, you are easily perceived to be a gatekeeper in the sense that, and this is my philosophy, if the leader of that particular court believes that you should act in their division or in their court, my philosophy is that please declare judgments that are reserved. Declare that you've got partly heard matters. It is an issue that sometimes gives rise to problems, but it is not a very serious problem to the extent that I have made it clear to the heads of those courts that the stance that I adopt is that I call upon judges when they are approached to act in those courts to declare reserved judgments, to declare partly heard matters. Maybe something that may become relevant at a later stage, which I would love to deal with. Let me look at the index on the issue about acting appointments in the context of who acts as an acting deputy judge president in the absence of a deputy judge president. I'm going to deal with that quickly. It should not detain us for long.
With regard to the perception of a judge president being a gatekeeper, if this would be of any comfort to you, that is the perception, that has been the perception around almost every judge president. I personally lived with that for the 14 years that I was the judge president.
Until you retired.
Correct.
Yeah, you never win there.
Yes.
You never win there. At the same time, it's all a matter of controlling it. You try as much as possible to deal with perceptions, but you don't win. But what is important for present purposes, thank you for interposing, Chairperson. What I would like us to go to now is item 30 of the index, pages 192 to 193. It's going to become relevant, pages 192 to 193. Page 192, small 192, 1722 of the main bundle. I'm just going to read the second paragraph. It's a letter penned by the Wild Coast Attorneys Association, attorneys in Umtata, basically. Paragraph 2 of the letter reads, I will try my best, Chairperson, not to mention names. I've seen how things have unfolded. Where I must mention a name, I will, but where I believe it is not necessary, I won't. But if you read the letter at page 192, the second paragraph, I'm here dealing with challenges. We hereby kindly propose that you consider the judges who are appointed, who are appointable, should there be a vacancy, and who are conversant with the practice within our jurisdiction, such as, then they mention 2 judges. Now you will see that the concern here is that I had appointed a particular colleague as an acting DJP. So, next page, page 194. Actually, we are going to page 195.
Just a second. Sorry, yes.
Thank you, Chairperson. At page 194 is a letter that I wrote to the Secretary of the association concerned. Let's rather go to page 195 at 4.4. I am saying, is it being suggested that the ADJP is not appointable? If so, what criteria have been invoked in order to arrive at that conclusion? On what basis is it implied that the ADJP is not conversant with the practice within our jurisdiction? The ADJP concerned is somebody who practiced law for many years. He had become silk. He was steeped in civil procedure and civil trials. Somebody whose trust in whom I reposed my trust. And then the next letter.
Sorry, you were referring to paragraph which paragraph?
I was referring to paragraph 4.4. This is where I engaged the association concerned to come out clearly in relation to what exactly their problem is or was. But then we can go to page 199. 199, small 199, otherwise 1729, which is on the top right-hand side. 199, paragraph 12. The association concerned responds. They say, this particular judge is junior to many of the judges in Umtata High Court. His selection to act as DJP is both unreasonable, thoughtless, and humiliating of the judges in Umtata High Court, some of whom are senior to him. Even when looked at in terms of succession planning, the judge, and I'm not going to mention names, cannot be relied upon to be elevated into judicial leadership in the future, even apart from his demonstrated oppressive style of leadership. His age rules him out. Now, these are practitioners writing a letter about and concerning a judge. All I did, as will appear at page 201, I forwarded the letter to the judge concerned and requested him to favor me with his response. Then, moving a bit forward, page 209. Page 209, paragraph 17. The judge concerned deals with the issue under attack. He says, if age is anything to go by, they must ask the JSC why a judge over 70 years was appointed as DJP in one of the divisions in this country. That was his response. But let's read the last paragraph of his letter, some form of lamentation because of the attack by the association concerned. Paragraph 19. In conclusion, I must say it is regrettable that these attorneys decided to choose an arrogant manner in the tone of their letter, which is disrespectful towards me and an insult to you, me as JP, and the minister for recommending and appointing me as DJP instead of then he mentions judges. And finally, on this point, yet another society called the Mtata Society of Advocates saw it fit to straighten the record. Could I take the tribunal to page 210B? 210B. I don't want to read everything, but it is a letter that deals with the various concerns that had been raised. Paragraph
Sorry,
6.
sorry, just a minute. Page 2.
Page 210B. On top is 210, capital letter B. The JP's discretion to appoint an ADJP in one of the Eastern Cape High Courts, they deal with that. Then they say the JP's appointment of, they mention the judge concerned. Then they say, I am being accused of overlooking some of the colleagues, they mention their names. And then the JP's reviewing of the decision to appoint, they mention the judge's name. And then something is said about robing by advocates in the lower courts, something that should not concern us at this point. Now, they say at paragraph 7, at the outset, it must be said that we feel very uncomfortable that the names of our two esteemed and honorable judges are a subject of this debate. and probably without their knowledge or consent. We regret, however, we are forced to do so. So the Mthatha Society of Advocates was expressing, they were expressing their disquiet insofar as certain charges were mentioned in a letter as being persons who should have been appointed. But most importantly, at page 210, capital letter C, they refute the suggestion that other charges have not been considered for acting as ADJPs. And indeed, they are correct. And this is what they say at page 210C. By way of narration, in the past 3 years, we have had the following justices appointed as ADJPs: Justice Makaula, Justice Bloom, and Justice Dawood. I mention those because there's nothing really controversial, in my view, about that. Sorry to have taken long, but I'm about to round off on this issue about challenges. I have dealt with the issue of gatekeeping, or the last one that I would like to mention, not necessarily because really it's the last thing that one should mention or can mention. There was a name change of Grahamstown to Makhanda, which was challenged by the residents. That case was not successful. The name Makhanda remains instead of Grahamstown. Now, in the course of that, I then issued a directive in terms whereof Port Elizabeth became Gqeberha Court, Gqeberha High Court, and in terms whereof Makhanda became Makhanda High Court instead of Grahamstown. There was an issue in the Daily Dispatch, Eastern Cape Herald, within the context of the name change and my changing the name of the court to Makhanda. Just mentioning that quickly in passing. But most importantly, I have had to encounter challenges relating to the recommendation made by Justice Mbenenge that the seat of the High Court should move from Makhanda to Bisho. The stance of the judiciary in Makhanda under my leadership and the stance of the judges generally was that, brothers and sisters, let's keep away from this debate. We serve the constituency wherever they are. The matter of where the headquarters is not a matter that really should concern us, more so that it might become the subject of litigation. As was the change or name change to Makhanda, it became the subject of litigation. It was the subject of an application for leave to appeal to the SCA. And so the stance adopted was that much as individually people may have preferences as to where the headquarters is, but fact of the matter is the judiciary can only place it on record that, and which is what I did before Mbenenge J, that on the issue of where the headquarters should be, the voice of the practitioners is paramount. The voice of the constituency that is served by the practitioners is paramount. There's been pressure on me to say something. Chairperson, I will not say anything about the move from Makhanda to Bisho. I will serve the judiciary wherever the headquarters is. It is a matter to be decided on by Parliament. It is a matter to be dealt with by the relevant functionaries. Mbenenge J has made a recommendation. It's served before the JSC. As to what the politicians will do about it is a matter that should concern us, really, as the judiciary, especially as I've indicated. It might become the subject of litigation, and we will have stated our views in relation to that, which may lead to problems. Thank you,
Thank you,
Counsel.
JP. Thank you, JP. Let's move closer. You said to the tribunal that this topic, as relevant as it might seem, will become relevant when we deal with another thing. But let's get closer to the meat of this issue.
Thank you.
The accusation that you are here about leads to some kind of description. One's description of one as some kind of barbaric, sexist, misogynist. And in that context, because that's been the label generally you will face, I want to ask you this question. What is your personal view of women?
Those labels are hurtful.
In fact, let me add, what
But
do
let
you
me-
see women as?
Women are as important as everybody else is. I respect men, I respect women. Because we are talking in the context of women, I value women. I'm born of a woman, I was raised by a woman. But on this issue that you've pertinently raised as to the perception, I've had to endure those labels. This is the third year now, and I'm happy that I've been afforded the opportunity to come here and ventilate myself in relation to that. Chairperson, I have appointed females to act in my division. I have encouraged secretaries to study law. So much so that one person who was once upon a time my secretary, I encouraged her to study LLB. I am proud to say at this moment, she's practicing as an advocate. I have delivered lectures to aspirant women judges. I don't have to come here with statistics to show how many women were appointed to act as judges from magistracy, from ranks of attorneys, from ranks of advocates, from ranks of academia. Those are things that I have done. And yes, maybe the less said about those hurtful labels, the better.
Well, JP, let's get straight to those. Because the real question that I want you to deal with is, do you see women as some kind of objects for your lust, or people with whom you can have meaningful relationships, romantic, platonic, or professional? What do you see them as?
I see women as persons who can engage in whatever form of relationship. And what is important is for them to be treated as persons. And this notion that I look down upon women in the manner in which you've articulated, I submit, or let me say, has no factual basis. So I see them as important as everyone else to enter the legal profession. You probably would, when reading some of the judgments that are reported, many a times I led females as silk. I was one of those persons who were very passionate about pupillage and lecturing pupils, including female aspirant advocates. I hope I've captured the essence of your question and have proffered an answer that covers everything.
Well, let's take a step further from that, because let's get closer to the complainant. During the evidence in chief of the complainant, we had so much about the concept of the fact that you are a judge president, power relations between you and someone who's either not a judge or not your age or not a judge president or a clerk. In those parts, you are a judge. And there's a theory that a person who's as old as you, who's a judge president as you are, who's a judge, cannot and should never seek to have a romantic relationship with a person of a lower class, age, status, category at work, or with less than you do. Could you favor the tribunal with your answer to these questions?
That is a notion that is hard to fathom. The notion that a judge cannot have affection. I just say affection, or may not be interested in somebody. I believe that there's a fallacy when it comes to that. I think what is important is to view people as adult individuals. They are free to engage in whatever form of relationship as long as there's mutual consent. Your question was a bit lengthy. You mentioned something about age. When it comes to age, all I can say is I would never query a woman who is older than a man in a relationship. I would never query a man who is much older than the female party in a particular relationship. I don't want to say age is a number. All I need to say is what is important is that the adults that I've just mentioned are free to engage in whatever relationship they would like to for as long as they are adults.
What is your response to the theory that you are a judge president or you are a judge? You should not seek to have any romantic engagement with someone below your class?
This thing about class distinction during this age and era is something that I look down upon. I don't believe that a JP, when it comes to engaging in whatever relationship, they are confined to persons of the same class. They are human beings, and they are judges in any event. Let me rather not even say anything. Let me just mention it in passing. I know of judges who married their secretaries in this country. Heavens did not fall.
Well, the answer will be two wrongs don't make a right.
I don't
those
believe
who
there's.
believe that
I
it's
don't
wrong.
believe that there was anything wrong.
Right. Let's come again to the entire concern that has been a running theme about this. That this entire case concerns a rather painful saga of sexual harassment, as described in legal terms, objectification of women, and maybe a humiliating experience both you and the complainant may have gone through. Let's get to the meat of it. Your flirtatious, salacious conversation with the complainant, how do you describe them? What were they and what was their purpose?
It is indeed true that it came to pass that I became interested in relating with the complainant. And I don't believe, can you just ask the question once again, because the nub of it I just want to follow.
Is what was the purpose of the conversations?
The purpose of the conversation, firstly, flirtation, the way I understand it. Flirtation is actually a playful way of interacting with someone that you are interested to have a relationship with. So flirtation is a playful way, informal, where you interact with someone that you are interested in, and this is what happened in this instance.
Yes. Mr. Matanzala's obsession with tea tells me that it's 11. Chair, I don't know whether it's the right time to adjourn.
Maybe let me, if Chair can allow me, just to round off my answer.
Yes.
I'm a member of the judiciary. The complainant is a member of the executive arm in that she's employed in terms of the Public Service Act. I am not her supervisor. I am not an employer. I am not an employee. Members of staff under the OCJ as a department have their terms of employment, terms and conditions of employment regulated by the Public Service Act, which doesn't apply to me. You may listen to the rhyme and rhythm as I talk about this, but I'm just mentioning it purely at the level that things are just like that. I'm a member of the judiciary. I'm not the supervisor. I will elaborate on this when we resume, if need be.
Thank you, Chair. Because I'm going to move to the next theme, I would think this is the appropriate time to adjourn with your leave.
It is. We'll come back at 20 past.
Thank you, Chair.
Mr. Sikakani.
Thank you, Chair. JP, let's round off this point you were making about your position in relation to the complainant at the workplace.
Yes, thank you, Chair. May I refer the tribunal to page 215 of the bundle that we will be making use of?
Page, what page?
215. Page 215.
Thank you.
There are two paragraphs at page 215. There's the one that says the respondent has a tendency, and then I'm focusing on that paragraph, but lines 1, 2, 3, 4, 5, 6. I'm just going to read a sentence there. Where the complainant, in a letter she penned in response to a request for particulars, he says, he, referring to me, involves himself even in court administration, swapping secretaries for his own benefit. I hope the chair has picked up that.
Yes, we have.
Thank you. Now, I am saying this in the context that I am seen as somebody who interferes unduly with things within the establishment. But for a proper context, I would like to take the tribunal to page 217. Page 217. Selection committees for the filling of the advertised judges, secretaries posts, PSC, Eastern Cape, and so on. Now, there are 9 names mentioned. There are columns in that page. It mentions the court, the post title, reference number, but most importantly, selection committee members. The issue is whether a JP employs secretaries. The answer is, to some extent, what I'm going to read here will demonstrate something about it. Chairperson, in practical terms, the modus in my division is that when a secretary is being interviewed, insofar as a judge must be part of the panel, it must be that judge whose secretary is being appointed. So this notion about me interfering with secretaries and all that, with due respect, has no factual basis. Let me take the tribunal through this document. Grahamstown, Makanda, as we now know, Judge's Secretary, Miss A. Sidlai, the first person to become a secretary, who was actually taken through the mill. It says Judge President Mbenenge, then Mqoqwana Lungisaceza. In other words, we were part of the selection committee. That lady was going to be my secretary, so I featured. The next name is Mtata. The secretary is B.B. Vuko. Jolwana, J, is Judge Jolwana, featured there, I did not feature. Grahamstown, the name is Miss A. Mengo. Judge Robertson featured, I did not feature. Grahamstown, once again, Miss Kusnell. Judge Smith featured because he was the one who wanted a secretary. Grahamstown, Miss Zet Ngai, the lady who testified, who regrettably has had to resign for the reasons she mentioned. Judge President Mbenenge, I was part of that. And then if you cross over, Port Elizabeth, Chiva, Judge Pakati. Then Makanda, Miss A.N. Madolo. I was replaced by Judge Norman, I believe. I did not feature there because my concern was, let me not feature insofar as a particular judge would like to become part of the panel. And then lastly, Makanda, Miss S.L. Kramer, Judge Bloom is the one who featured. This document, by the way, I was furnished with by the HR section, and I don't beat about the bush about it. Somewhere I mention, and this is what I'm planning to say, that everyone who cooperated with me, availing information such as I have here, have come to me and said, we're being victimized for interacting with you. But thanks to the HR men who furnished me with this document. Then next at page 219. Page 219 is a document that I also requested from the HR department. I have no clue when it comes to these matters. Annual performance assessment for employees on salary. This document starts from page 219. Let's consider page 223. The name of the employee will be mentioned according to what appears on page 223. Then the supervisor, I'm not the supervisor, I don't supervise secretaries. And then head of the unit, I'm not the head of any unit. And then right at the end, chairperson of the moderating committee. And then last page is page 224. This form is important insofar as it demonstrates that there are performance assessments that are done, I believe, on an annual basis. I've got no clue, but I asked the HR section to furnish me with a document that shows that, that shows who the role players are when it comes to assessment. I did so because I've never featured when it comes to that. So, Council, the long and short of it is I don't supervise secretaries.
Thank you, JP.
Actually, even my own secretary is not supervised by me, to the extent that she interacts with me on a daily basis, but I'm not her supervisor.
If you know this, who supervises secretaries?
There is, on a station-by-station basis, somebody who supervises secretaries, who is responsible for allocation of things, for instance, during recess, as to what should be done in the event that one's judge is not busy with a partly head matter. I don't have names right now as to who is who, in as much as I don't feature there, but I do know that according to the functioning of the line, there is somebody whose role it is to supervise secretaries. And the ultimate person will be Mr. Kokwana as head of the administration.
Right. JP, let me get closer to the bone.
Yes, I was looking forward to that. Thank you, Council.
Since this matter started, since private conversations between you and the complainant were made public, since the complaint came and things were placed on social media, what have you and your family, or you in particular, what have you gone through as a person?
Maybe the starting point is at the outset to say, I have consciously decided to keep my family out of this. to respect their privacy, and I've chosen to say nothing about them. That is the starting
you.
point. But coming closer to the substance of your question, I saw myself being treated like somebody who is presumed guilty until proven innocent. That has been the story of my life. The first thing that happened, and this was championed more by the media, this thing about this step-down campaign, in circumstances where the law is very clear, judges are suspended when they have been found guilty of gross misconduct and their matter is serving before the National Assembly, or is to serve before the National Assembly. But there was this campaign for me to step down, whose basis I could not fathom. I even remember on one occasion, I had been invited by the University of Fort Hare to become a panel member, the topic having been traditional affairs and constitutionalism. I had this sad experience of a colleague of mine, a senior member of the judiciary, who was nudged, who together with the vice chancellor of the university were nudged by this journalist. The journalist that I mentioned earlier on. The issue being, this man has committed a serious offense. Why are you inviting him here? That is the story of my life. This is what I've had to endure. Being labeled as somebody who is guilty when due process was still in motion. Let me also mention something quickly. That has to do with what I had to endure. On one occasion, and here, even though I'm going to talk about my son, the focus is not my son, but it's me. He finished his articles, he wrote the board exam, and was admitted to become an attorney. The convention is that judges admit their sons. And if they happen to have members of the family who are lawyers, they move the application. This is what happened in this particular case. On 17, I think it must have been 17 October, I presided over the admission of my son. I was on leave, and I had the nod of the Chief Justice. I informed him that there is this, I'm on leave, you've granted me leave. However, as a matter of tradition, I would like to admit my son. I'm not talking about my son, I'm talking about me. Then I became the subject of media. I was criticized for going to court, and the issue was, who are you, lacking morals, to go to court and actually admit somebody? Because there were quite a number of persons who were admitted on that occasion, and I had few words of encouragement to them. And there was this criticism that was part of the media reports. There's one occasion when a colleague of mine called me telephonically in the morning. Apparently, there was something about a criminal case associated with this, whereby she mentioned that, JP, I have been called by the police. I just thought, as a matter of courtesy, I should inform you. But later on, it turned out that she had recorded me. And this voice note was circulating virally. I choose not to mention names because I don't want to derail the course of these proceedings. Yes, there was an attempt on the part of my attorneys to have that particular judge subpoenaed to come here, but I want to leave it there. So I've gone through a lot. It was painful, but I think the advantage was that I had to find whom Mfanelo really is. and learning that people love one for who he is, not what, for who he is, not what he is. I've come through with that notion. In the midst of media attacks, being labeled as a sex pest and all that, I've had to find myself. I could go on and on and on
And what did you find?
about myself.
Yeah, what did you find? Did you find a perfect person?
Well, I was just going to deal with that. No one under the sun is perfect. I am saying this knowing full well that this tribunal is not about whether I am perfect or not perfect. But, counsel, my imperfections became the subject of thought on a daily basis. And the pain that I've had to endure is being ostracized by some persons, people not reaching out to me trying to reach out to them because of this dark cloud that has been hanging over my head. I've had to make sure that I soldier on.
Thank you.
I never claim to be a perfect person. I interact with persons. I believe none of us in this room is perfect. But I had to embrace that and carry on with my life.
Thank you, JP. Let's move to, this case has been about chats, flirtatious chats from you or from the complainant, depending on the number. But I think largely the head issues have been about the 14th of November, 2022. The so-called incident, indecent incident. The second issue is about you allegedly sending a picture of your private part. Those are the two head issues that have covered what you are and what you are alleged to have done. Would you deal with the issue of the 14th or the 15th and its history and the indecent incident as it is alleged, so that we get over this once and for all from your words, from your own mouth?
Chairperson, I would not love to look down upon the functionaries that couched the charge that I'm facing here, which relates firstly to whether the chats that were shared between the complainant and I were wanted or unwanted, which in my view is an important issue and at the heart of these proceedings. But additional to that, there's the issue about the 14th, or call it 14th or 15th November, which is something that I've had to endure. I look at it as a campaign to shame me. It is lies. It never happened. The complainant knows, much as I do, that it never took place. Now, I'm going to take this tribunal through a pathway before I deal with the answer, pertinent answer. Did you do that which you have said you have done either on the 15th or 14th? I need to take you through, Chairperson, documents. Some of the things that I'm going to refer to are known by the tribunal, but context is very important. I wish to put things in their proper perspective before I deal pertinently with what happened that affects me on the 14th and the 15th. The starting point is that nothing of the sort happened and yet this has brought much pain. I do not mind being accused of things I did, but not things that I did not do. This goes for the event or incident of 14-15 November 2022, and the pictures of the private parts that I'm said to have sent to the complainant, which is a lie. I will deal with this thing about pictures separately. Now, may I be allowed to deal with 14-15?
Can I ask you this question? Is it 14 or 15 November? In terms of what you are accused of, what exactly is the date?
I will answer that question in the course of what I'm going to present. It suffices for present purposes that I am still at a loss. I'm at a loss because it never happened. I'm also at a loss because from the complainant's camp, it's either 15 or 14. I don't know why, but I'm going to deal with that. Chairperson, I can't help but refer you to page 10 of the document. Page 10 of the bundle. And I must say, in my view, this thing about 14 November is not only false, but with due respect, it is malicious, and it is being pursued by the camp on the other side to shame me. I'm going to demonstrate this before I answer pertinently. I've referred the tribunal chairperson to page 10.
Yes.
This is the notice in terms of Rule 4 of the Rules Regulating Procedures before the Judicial Conduct Tribunals 2012. It's addressed to me, care of my attorneys of record, which indeed I received at the opportune stage. Now it says, with reference to the notice of hearing before the JCT, which is this tribunal, which is served on you along with this notice, the following information is provided in terms of Rule 4 of the Rules Regulating Procedures before the JCT 2012. Number 1, it is alleged that the facts set out in Annexure A to this notice constitute a complaint of incapacity, gross incompetence, or gross misconduct against you. I'm not going to quarrel with the person who crafted this insofar as it refers to incapacity or gross incompetence. I choose not to delve into that. But for the sake of caution and completeness, I did say something when I started testifying. But let me focus on gross misconduct on the basis that I am said to have done something. Let me read further. Then it says, a concise summary of the evidence and any other information which substantiate the complaint against you is set out in Annexure B. So Annexure A, if you go to Annexure A, it is the complaint by the complainant. That's Annexure A. Annexure B is actually what one would term a charge sheet. And I'm not going to deal with interpretational issues. I'm simply going to go straight to it. It says, concise summary of the evidence. It is alleged that between 2021 and November 2022, you sexually harassed the complainant, Ms. Andiswa Mengo.
Just a minute.
Page 26.
Oh, sorry.
are yet to
I got carried away. Sorry, Chairperson. Page 26. Small 26.
We are there now.
Thank you. Now, we are there because the summary or substantial facts are that I sent her on WhatsApp messaging service unwelcome or unwanted messages of a sexual nature, as well as crude pictures. And then I behaved indecently towards her in my office at the High Court in Umtata. I pause there. Let's go back to page 10. With your permission, Chairperson. Page 10, paragraph C. A copy of the following documents: the WhatsApp messages and statement of Acting Deputy Judge President Tokota, which are to be presented to the tribunal is attached as Annexure C1 to C43. We now know that when the complaint was lodged, a bulk of documents did not serve before the JCC or the chairperson of the JCC. At the opportune stage, I will place before this tribunal that document, which on its own shows what did not serve before the JCC. By now, we have a clue or an idea. Then it proceeds at page 11 to say, a copy of the video footage on 15 November 2022 depicting the area around your office at the High Court in Umtata, which is to be presented to the tribunal, will be forwarded as soon as it is received. So those who set in motion this process, the process insofar as it relates to the tribunal, not the JCC or the JSC, the process insofar as it relates to the tribunal, in their wisdom, couched things in the manner they did. But then, Chairperson, could we go to page 21? Because we are told that this complaint is enshrined in the complainant's affidavit. So page 21 is part of the complainant's affidavit. At the moment, I'm not going to be highlighting things that relate to the complaint in its broader sense, but I'm dealing purely with 14 and 15, 14 or 15, 15 or 14, whatever the case may be. Paragraph 20, painful though it is, I'm going to read this paragraph line by line. It was on Monday, 14 November, me, called me to his chambers and asked me why I am wearing colorful clothes when it is a court day. I told him I'm not going to court, but my colleague is. He said he was concerned about me. I was concerned about the decorum and not saying that my clothes were not appropriate. This is the complainant telling everybody, the world over, the universe over. He said he was concerned about the decorum and not saying that my clothes were not appropriate. That was not offensive, I must say, and I was not the only one present on that day. I paused there. And sorry to have to digress, but I will quickly return to the substance of my presentation. Today, the evidence leader has got the audacity, with due respect to her, to say that, among other things, I am being charged for ridiculing the complainant, among other things, because of this event of the 14th. Chairperson, I'm just dealing with the 14th, and what I'm highlighting is that that was not offensive, I must say, and I was not the only one present on that day. That is what happened on the 14th. So what happened on the 14th was the interaction between the complainant and I and my secretary and Ms. Kukushe, who was in the office. We know now, according to Ms. Nkai, what happened. I've yet to deal with that. Then the complainant says a day later can only be the 15th. He sees me walking down the corridor and imitates how I walk. I didn't comment, I walked past instead. On my way back, court floors in Umtata is tiled, so you ought to hear who walks past if you know footsteps. He knew my footsteps, I don't know why and how, anyway, and he stood at the door and calls me in. He stood at the door and calls me in. I noticed that his secretary was not in her office. Got in and he showed me his trousers and said, "Do you see the effect you have on me?" The question that followed was, "Awufuna uyimunca," loosely translate, don't you want to suck it? He unzipped his pants and attempted to draw his erect penis, and I ran out of the office. I went home and thought about what had happened, then decided that on the following morning, I will tell him where to go off and so on. Now, we have heard it said, even in the broad context of civil proceedings, that, and I'm just talking law in the broad sense, insofar as the law, and everybody who is a lawyer knows this, that a litigant is not entitled in their pleadings to point somebody to a particular cause of action. And then when the trial is pursued, pursue it from other facts altogether. I don't want to be quoting case law on that. But I'm just mentioning that the affidavit that forms the fons et origo of this complaint tells us that something happened on the 14th, not offensive. Day later, on the 15th, something happened, allegedly happened, and it is what I've read. It pains me to have to read it. I hope I won't have to do it again, in the sense that as I'm presenting, I've got to talk about it. So this is what we are told in the complaint. 14, this is what happened. 15, this is something else that happened. In circumstances where we know, according to the complainant, he had been to the OCJ at some point, he was assisted in crafting some affidavit, he was afforded the opportunity to rectify certain things, and this is what we have. I am said to have done something on the 15th. Chairperson, I did not do it. Could we go to page 88? At some point during the day on 14 November, I was in my secretary's office having a chat with her. My secretary's colleague, Ms. Gugusha, was also present. Insofar as I was called upon to meet this case, this is how I dealt with it before the JCC. We saw Ms. Mengo the three of us walk past the door of my secretary's office. I called her and she stood approximately a step past the doorway into my secretary's office. She was not wearing the usual black and white apparel used by judges' secretaries. So I commented in jest about her dress code. I normally comment about the expected dress code in the courthouse. This has been the position since my days as counsel. The world over, let me say the country over, those who have interacted with me know that this has been my style. Those I was with at St. John's College, those I was with at the University of Transkei, know that I may be a bit pedantic about how I appear. Maybe that's why I'm called cute Londo and so on, something I'm going to deal with later on. I'm just mentioning this because I'm saying this has been the position since my days as counsel. I could call 100 witnesses to come and say, JP is very particular about dress code. And if I were to be asked why I'm particular about this, it's got to do with the fact that sometimes standards dwindle with how we appear. I don't want to talk about departments and health department and how nurses used to appear and so on and so forth those days when we grew up as boys. But I just had to pause here. 37.4. Understanding the spirit in which this was said, she jovially responded that she was not doing court work on that day. She left being in a good and jolly mood. This was on Monday. Beyond this, Chairperson, I never interacted with her again. All I got was this complaint in the course of time. So I'm dealing with the 14th. Everything that I have said ties in well with what the complainant says in her affidavit, founding the complaint. Then let's deal with 15. On 15 November 2022, from the time I arrived in my chambers around 9 until I left around noon, I had no interaction whatsoever with Ms. Mengo. I say that under oath. I had no interaction with Ms. Mengo on the 15th. The only time I interacted with Ms. Mengo on the 14th is what is common cause from her complaint and what I have said in answer thereto. Chairperson, could we move to page 101? Page 101 is part of a document headed Request for Further Particulars for purposes of preparing for an inquiry conference. Then page 101. To enable the respondent to prepare for such inquiry conference, which will be held, and with a view to clarifying issues for determination at the hearing.
Chair, can I take you, JP, back to where you were? Because you didn't finish that. At paragraph 89, page 89.
Page?
Page 89.
Oh, page 89. 89.
Yes. Paragraph 37.6.
Oh, yeah.
I would like you to deal with that aspect because you
Thank you
talk
for
about
reminding
CCTV
me.
footage.
This is me in an affidavit filed to defend myself before the JCC, before the matter was referred to this forum. It should be possible for the CCTV footage of the events of 14 and 15 November, to which I believe will bear me out, to be obtained. I was just expressing a view on the understanding that all is well, and I believe all was well until something that I can't testify to may have happened or may happen. But I would like to go back to page 101, if you allow me. At paragraph, and I'm reading paragraph 1, Chairperson and members of the tribunal. At paragraph 20 of the complainant's complaint, the complainant alleges that on 15 November 2022, at his Umtata High Court chambers, the respondent called the complainant to his chambers, unzipped his pants and attempted to draw his erect penis, and the complainant ran out of the office. At what time, this is the request for particulars, at what time on 15 November 2022 did the alleged incident take place? Time is of the essence, Chairperson. You can't have something like this befall you or beset you and not know the time. We know that it is said to have happened on the 15th under oath. At what time did the complainant leave the court building after the alleged incident on the day in question? And then what are the details, the number plate, the model type of a car, whether it was hired or state vehicle or vehicle used by the complainant on 15 November 2022? What are the details? This information will be furnished to track the movements of the vehicle on the day. For the record, the respondent's vehicle on that day, on the day in question, was a white BMW X5 with registration letters and number JJL482EC. Chairperson, let me pause. These proceedings are inquisitorial. The officer leading evidence is not a prosecutor in these proceedings. She is officer leading evidence. That is why, in your wisdom, Chairperson, at some point you had to ask, are you going to lead your own witnesses or are you going to leave everything to the evidence leader? It must have dawned in your mind that the inquisitorial system is not something that most of us are au fait with. Well, let me say in South Africa in particular. And we've got my learned colleague, the evidence leader. I call her colleague because she's a lawyer. So this information is sought. Why? Because it is incumbent on the officer leading evidence to conduct investigations, not to be partisan. She is told that Mbenenge was driving, by my attorneys, Mbenenge was driving a particular vehicle. Reach out and get tracking reports so that we bring this information here. Whether that happened is something that we are going to deal with shortly hereafter. Further, the respondent requires full day video footage of all entrances, front and back, and passages at the Mthatha High Court building on 15 November. Let me end there. There's a lot of particularity that was sought, but I choose not to read everything. I choose to read that which I believe relates to what is important. Then, Chairperson and honorable members of the tribunal, at page 105. This document is very important. It is of significance in that it is a decision taken by the tribunal in relation to issues that were raised by my attorneys, directed, among others, at the officer leading evidence. Number one, a pronouncement is made because we were seeking particulars. Those particulars were not being furnished. One, the respondents request that the complainant states the time of the alleged incident of 15 November 2022. Let me read the pronouncement. The complainant is required to do so, to do as requested. If she is not able to give the exact time, she is required to give the approximate time, or at least say whether it was in the course of the morning or in the afternoon of that day. This information must be given to the tribunal secretariat as well as the respondent's legal representative within 7 working days of receipt hereof. The fact that it was not furnished within 7 days is nothing that I will make moment of. Then paragraph 2 relates to the footage. The tribunal will, in collaboration with the security company concerned, as far as possible, arrange for the holding of the above identification parade comprising security guards who were on duty on the morning of 16 November, being the date on which the complainant says she was told of the deletion by one of the security guards when she arrived at work that morning. Something has been said about deletions, obliteration. At least we know where we are, that evidence has disappeared into thin air. Chairperson, let me not argue the case. It is in the hands of capable lawyers. But I'm dealing with page 105. Then moving to page 107. Page 107 is a letter written by the Women's Legal Center. Chrissy Blows. She's the author of the letter. Shall we go to page 108? I'm going to read in your hearing, Chairperson, paragraphs 4, 5, 6, and then paragraphs 8 and 9 to the extent relevant. I may not read the entire paragraph because I'm focusing on the substance of what is being said by the lawyer concerned. Paragraph 4, we note that as previously indicated, the complainant was unrepresented at the time she made a complaint of sexual harassment against Judge President Mbenenge. She was not legally represented. But we know the background and who assisted and all that. I'm not talking about, at least for now. It is our instruction that to the best of her recollection, the incident which the complainant describes in her affidavit at paragraph 20 correctly reflects the chronology of events, and that the only confusion in her recollection may be whether the incident of the unzipping of pants happened on the same day that the Judge President commented on her clothes or on the 15th, as indicated in her initial statement. Here starts vacillation, Chairperson. In Xhosa, I would say, yaqalisa ukuba mtyibilizi le nto sithetha ngayo. I would love you to interpret that. Iyaqalisa ukuba mtyibilizi le nto sithetha ngayo.
I will first give the direct translation and then give the interpretation of what the JP just said, with your permission, Chair. It is now what we are talking about becoming slippery. That's the direct translation. If we were to interpret it into the context, it is now becoming very much interesting, that which we are talking about.
Thank you, Chairperson. I've got no problems with the interpretation. Paragraph 6, she, however, advises that given the psychological effect of the sexual harassment that she has experienced. Now, at this point, we know that there were chats in 2021 up to and including February 2022. And then we know that from February until November, we've got March, April, May, June, July, August, September, October, November, 11 months. But something is said about psychological effect. Maybe it's the unzipping or something else. But if it relates to the unzipping, That never took place. It's a lie. It is being pursued for malicious reasons. Then let me continue. So across the page 109, the complainant advises that she has attempted to work out when the incident took place and that to the best of her knowledge, she recalls that the incident took place during the week after the judges' farewell conference, which happened on 12 November, as she can confirm that both she and the judge president attended the same event. And I think I alluded to that in my affidavit. The fact that prior to this, there was a farewell function. I met the complainant. She was jovial towards me, as happy as a bee. Then somewhere, something is said about psychological effect. Anyway, paragraph 9. We are therefore instructed that to the best, and this is the most important paragraph, we are therefore instructed that to the best of the complainant's recollection, the incident happened on either 14 or 15 during the course of the afternoon. The complainant further instructs us that she provides this approximation of time because she recalls that while the judge president's secretary was in office during the morning when he made a comment about her dress code and decorum, she recalls that the secretary, and this is where the emphasis is, the secretary, Ms. Nkai, had left for the day and was not in office when he called the complainant into his office and gestured towards Spence as indicated in paragraph 20 of her affidavit. So we are told in this correspondence that it was at a time when Zinhle had left for the day. This is Mengo's attorney addressing the tribunal. Then page 110. It is therefore our request that on the basis of the dates provided above and to ensure that the tribunal has all the necessary facts before it, the video footage of 14, well, should say from 14 and 15 November be secured for viewing for the estimated times between 11 and 4 p.m. This therefore narrows down the viewing of the video footage for the 2 days only as they are relevant to the complaint. Let me leave it there. Let me move to something else. Then, Chairperson, somebody has spoken about what they call a smoking gun, something that would, when placed before a forum such as this one, will cause a bell to ring on the other side. That you keep on pursuing this thing about 14 and 15. You are provided with any and every information to investigate within the context of an inquisitorial system the true facts before you can pursue it further. This is me addressing this issue on affidavit, knowing full well that I'm supposed to come here and testify. And my prayer had always been, sense is going to prevail at some point. This thing about 14, 15 is surely going to be abandoned. I'm going to delve deeper into that. So at page 125, paragraph 6, 7, 8, 9, 10. Upon a reading of paragraph 9 of Ms. Mengo through her legal representatives, suggests that my secretary, Ms. Zinhle had already left on Monday afternoon on 14 November 2022 and was not present at the time of the alleged event under discussion. This is me talking. I'm trying my best to summarize where we are. The issue is that this thing happened on the 14th and no longer on the 15th. It started off something like, well, it may have occurred on the 14th. So, paragraph 7, I instructed my attorneys to secure the Mthatha High Court visitor's laptop register for the week of 14 November. This was done. The registrar is is signed by all OCJ employees not stationed in Umtata deployed during the stint at that center as they enter and leave the court premises whilst in possession of laptops. A copy of the relevant page of the register is annexed here to marked A. Now, it is indeed annexed, but I choose to deal with it when I deal with something else, which is going to follow shortly hereafter. So all I was saying, insofar as it is being suggested that my secretary had left when this false thing or this allegation or this alleged incident happened, my secretary had left, there is this laptop register. One would have expected the evidence leader to interact with the court manager and find out exactly what the position is in relation to this register. My persistence, Chairperson, was I was not looking forward to this day when I'll have to testify about something that never happened. And we've got to deal with a graphic detail about something that is false. I was trying my best to ensure that we don't reach this point. We don't reach this point because I believe there were ways to investigate this and find that it is a fallacy. I'm going to delve deeper into that later on. Page 126. According to the register, the laptop register, Ms. Mengo signed for her laptop as she left the Mthatha High Court building at 16:30 on 14 November 2022. And 10.2, Ms. Ngai signed for her laptop as she left the building later than Ms. Mengo at 61 hours 41 on that day. Chairperson, I was hoping that, having alleged in the fashion I did, this thing about 1415 would be abandoned. Anyway, I am not a decision maker. I'm not officer leading evidence. I'm just mentioning this in the context that it was incumbent on whosoever to investigate the truthfulness of this. Because the issue was who left earlier than the other one. Ms. Mengo left before Ms. Ngai did. So says the register, signed by somebody at the entrance of the court building. Inquisitorial system. These proceedings are about investigation. One is expecting the evidence leader to go to Mthatha and interact with whoever signed that document, just to check the authenticity thereof. Then, paragraph 12, the Mthatha court manager, Mr. Mhlonhlo, is custodian of or has access to the relevant records and or registers, and independently of me, he may be conducted by the tribunal should that become necessary. All these are endeavors to ensure that this malicious allegation is not pursued. Page 131. Ms. Zinhlenkai is caused to depose to an affidavit. She's a married person. She's got a husband. She's got kids. We know the challenges associated with having to testify in a forum such as this and end up, for instance, being ridiculed one way or the other. But I was hoping that, with due respect, sense would prevail. Ms. Ngai is caused to depose to an affidavit. She says at paragraph 7, and the issue is about who left. Was Ms. Ngai away on that afternoon? That was the real issue, an aspect for investigation. I left the Mthatha High Court building at 1641 on the same day. This is signified by the entry on the register as I declared my possession of the laptop to security officers whilst leaving the court building on that day. I do recall that prior to leaving the building, I had accompanied the JP into Court A, Mthatha, where he had to deliver a lecture to Mthatha members of the legal profession. Then at paragraph 9, she says, as far as I can remember, this was the last time I saw Ms. Mengo on 14 November. According to Annexure A, she left at 16:30, earlier than me. So we had reached a point where the date may have become an issue. The welter of detail has to do with who was where and when. And there's a document in my view, very important document, which, when considered and interrogated as part of the investigative process, will reveal that Ms. Mengo left at 16:30. And therefore, what she said about Zinhle Nqayi having left on that day for the afternoon was flying in the face of reality. Chairperson, I take the tribunal to the annexure. I think it's page 133. Page 133 is the register. Evidence leader, this is the register. There's an issue here. Who left earlier than the other? This is a matter for investigation. So what we have, initials and surname, department, model of laptop, barcode, in time, out time, owner's signature, signature of security officer. These are people that could be interacted with as part of the investigative process. Then we go to 1, 2, 3, 4. We see that Miss Mengo, according to this document, left at 16:30. There is her signature. Ms. Nqayi left at 16:41. The evidence leader is supposed to conduct investigations to ensure that whatever is alleged has merit. In its wisdom, the tribunal at page 134 there's this letter from Mbali. Good day, kind regards, Mbali. It says the second sentence, the third one. The arguments raised by the parties relative to the date of the alleged incident in the respondent's office, as well as the date of the alleged tampering with the video, are matters for evidence. That's all the tribunal says. Well, we can't preclude the complainant from testifying about what happened or what did not happen. This is the view of the tribunal. And that's why I say, in its wisdom, the tribunal is saying, well, parties must testify about everything. But the tribunal is not saying whoever it is incumbent on them to investigate should not do that. So, that having been said, we get an affidavit from the complainant. Let's go to page 137, please, Chairperson and honorable members of the tribunal. So this is under oath. Because the attempt, at least for my part, was to resolve this thing once and for all. I mean, if somebody is going to say my secretary was away altogether, and there's a document that negates that, surely something should have dawned in the mind of the person whose task it is, in keeping with the inquisitorial system, to investigate fully. So let's go to page 137, paragraph 11. At paragraph 9, I instructed my legal representatives to note that, to the best of my recollection, the incident of gesture towards the pens happened either on 14 or 15 November during the course of the afternoon. I provided the approximation of time as I recalled that, and this is the most important part. While the respondent secretary was in her office the morning when he made a comment on my dress code and court decorum, she had left for the day and was not in her office when he called me into his office and gestured towards his pens. Ms. Nqayi has told the evidence leader and the complainant's camp that it can't be so that Zinhle left after, Zinhle was the first to leave. Actually, even this notion about her not having been in her office in the afternoon on 14 had been negated already. There's a register. But then the complainant at page 137, in an affidavit she deposes to, on 23 October 2024, in the heat of things, my attempt having been, this thing about the 14th and 15th is defamatory. This thing is malicious. So this is what Ms. Mengo says. She is insistent that when this thing, this gesturing, Zinhle had left for the day and was not in her office when he called me into his chambers and gestured towards his Benz. Chairperson, shall we go to page 141 of this consolidated bundle? Thank you, Chair. Paragraph 3. This is a letter written by those by my attorneys of record. Sorry for the suggestion that they are my instructing attorneys. Paragraph 3, page 141. Having regard to the fact that the allegation had all along been that the respondent had acted or behaved indecently towards the complainant in Umtata on 15 November 2022, the respondent, in preparation for this aspect of the case, requested from Ms. Salome Jafta of the Department of Roads and Transport, G-Fleet Management, on 15 March 2024, a trip report for 15 November 2022 for the motor vehicle he drove, to wit, a JJL 482EC. Registered motor. A copy of the report is forwarded herewith for the information of the tribunal, marked A. Then, this is addressed to the evidence leader. Paragraph 4. On the face thereof, the report was generated by Ms. Lesiba Nkwana of Tsalis Fleet, G-Fleet's service provider. The report was transmitted to the respondent via email on 18 March 2024. It traces the movements of the respondent's motor vehicle from approximately 8:30 to 16:30 on 15 November 2022. So we've reached this point where there is this suggestion that it was on the 15th, it could have been 14th, but in whatever event, it happened at a time when Ms. Nkai had left. So we cover ourselves, and I cover myself through my attorneys of record. Let the evidence leader know that there is a tracker for 15 November 2022. Oh, how I wished this matter had ended. I'm talking about this claim had ended at this point. There was a measure of benevolence, Chairperson. Something is said about the 14th. The case I'm called upon to meet is about the 15th. I've responded pertinently to the 15th. Then somewhere, somehow, an element of vacillation starts. But something is very crucial. Ms. Nkai had left, but we know from the laptop register, which is not in dispute, that Ms. Mengo left before Zinhle Nkai did. So this is at page 143. At page 143 is the trip report for 15 November 2022 to 15 November 20. It just deals with the 15th of November. I took it upon myself after the chairperson of the tribunal had indicated during those proceedings that were held around October that I should be active in collecting information that will assist the tribunal arrive at a just decision. So, because there was this, I thought it prudent that let me collect information for the 15th November so that we are done with 15 November. We bury it. Then, in keeping with what I said in my affidavit, I got to chambers around 9 o'clock. I left around 12 noon. I never saw Ms. Mengo on that day. The trip report shows that after attending to a few chores around Umtata, I left and got back to East London in the afternoon. The first place that I touched was the tribunals, we call it tribunal, the courtroom in East London. And thereafter, I went to the car wash. It was a Friday, and then, it was a Tuesday. I went to the car wash and then back home. I'm not going to take the tribunal through this document. It speaks for itself. It shows the movements and what happened. It tells us who generated the report. It suggests also that it was incumbent on the officer leading evidence upon receiving this. Say, hang on, something is said about the 15th, but let's check what happened on the 14th. These proceedings are investigative. These proceedings are inquisitorial. Chairperson, I am getting closer to dealing pertinently with what happened, my version of what happened on 14 and 15 against that background. But before doing that, I thought it prudent to refer the tribunal to a letter that was written to Ms. Songa at page 2, sorry, it's addressed to the evidence leader at page 268. Page 268 on top. It's a document that lists witnesses, the way we saw things. Page 268, Chairperson.
Yes, we have it.
Thank you. Page 268 is headed Complaint A. Mengo / Mbenenge, Judicial Conduct Tribunal. Witnesses to be subpoenaed for the tribunal hearing, travel and accommodation costs. Let me pause here and maybe for the last time, I hope, mention something that relates to our understanding of the nature of these proceedings, and I believe the way in which the chairperson understands them, the fact that these proceedings are inquisitorial. So, when you furnish the evidence leader with information, you are saying so-and-so may testify about this, so-and-so may testify about this, so-and-so, please subpoena those people. You are not saying to the evidence leader, which is in keeping with an adversarial system, which this is not. You are saying to the evidence leader, these are the people, feel free to interview them. Then, let me just go to page 270. Additionally, so what we had listed were witnesses we thought were the respondents, myself, witnesses. Then 270, say additionally we list below other individuals whom we believe should be subpoenaed. We mentioned these people, I don't have to call their names. 1, 2, 3, 4, 5, 6, 7, 8, 9. But I'm going to deal mainly with 4.8 and 4.9. And the context here, Chairperson, is to say, evidence leader, you are investigating in an investigative process. You are not the complainant's lawyer. You are not the prosecutor, such as in a criminal case. It is incumbent on you to investigate in the true sense of the word. To interview people so that when the time comes for this tribunal to hear evidence, we know who is going to say what. This notion about an evidence leader saying, well, here are the complainant's witnesses, the rest you will see for yourself, is not good. But let me go to 4.8 at page 271. We believe that it is important for the evidence leader to subpoena Mr. Lesiba Mkwana from Tsali Fleet, a private company providing tracking services for G-Fleet, who generated a tracker report regarding the motor vehicle with registration JJL482EC, which was driven by our client at the relevant time. Ms. Mkwana should be subpoenaed to testify regarding the authenticity of the tracker report. Then 4.9. The security officer who allegedly informed the complainant that our client had instructed the obliteration of the matrix system and or CCV footage on or around 14 or 15. The complainant is expected to identify this officer, and upon identification, we request that the officer be subpoenaed. This is an endeavor to furnish the evidence leader, to do his job, to investigate in an inquisitorial system, to interact with these people, so these proceedings are streamlined and things that are not in dispute don't have to be dealt with. Then I think this is more than enough, at least by way of background, Chairperson and honorable members. Question is, tell us, where were you on 14 and 15 November? Now I deal with that. Bearing in mind that the issue relates more to what might have or might not have happened in the afternoon on either of those days. So I'm at pains. What I was expecting to be delved into by way of investigation is not done. So, painful though it is, I must come and testify here. The whole universe is watching about something that is a lie. So, on the 14th, so I went to Mthatha on the 13th, by the way. I put up in Mthatha. Mthatha is my hometown. I put up on the 13th of March in Mthatha. In the morning at 9 o'clock, there was a meeting, and I say 9. There was a meeting of judges. Mr. Kokwana was to address judges because there had been a concern expressed by a colleague who had not been paid SNT. So I thought it prudent that Mr. Kokwana would explain at that meeting, explain something about what the processes are. So 9 o'clock on the 14th, I had a meeting with judges. There's a document which is of some significance that I would like to refer to. If the chairperson and honorable members can bear with me, because it's very important when I talk to refer to something. So I'm looking for this document that embodies a suggestion that I'm just gonna look for it. It's got to do with unhappiness on the part of a colleague because she had not been paid for attending, for having attended a conference of Saula. So I called upon Mr. Kokwana from the administrative side as representative of the OCJ dealing with admin matters to address judges. So I'm looking for this letter just to show that there was such a thing as a concern on the part of a colleague. And there had been endeavors on the part of the colleague concerned to have this matter thrashed out in a judges' meeting, but I decided that the matter should be dealt with at a local level, which is what I did in the morning. So 9 o'clock, I was with judges. The person who was addressing judges is is Mr. Kokwana. He testified here. At 9:30, I had, as said by Ms. Nzindlenkai, an application for leave to appeal. Feel free to help me, counsel. I think in the end,
Page 144. Page 144.
Page 144. Page 144. Thank you. Oh, yes. Here are these documents. So, page 144, let's go to page 145. Mr. Kokwana is addressing Deputy Judge President of Mthatha, page 145. Forget about what is above. Dear DJP, kindly find attached an email from President of Saula, which is self-explanatory for you. For your accommodation cannot be paid from government funds. Then I don't know what happened. The invitation does not something. Then it says, should she not be happy with this decision? She's at liberty to approach Mr. Kesi Kutsa. So there was unhappiness on the part of a judge in relation to attendance of conferences such as Saula, and Mr. Kokwana, from the administrative side of things, had to address on behalf of the OCJ nationally, or the national office had to address judges. So I'm in that tea room where we converged at 9. I was there. Why did I go to Mthatha on the 14th? Why did I go to Mthatha on the 14th? Among other things, let's have a look at page 147. This is a directive I issued in respect of Mvuleni versus the state. By directive of Judge President Mbenenge, the application for leave to appeal shall be heard at the High Court Mthatha on Monday, 14 November 2022 at 9:30. So there's nothing very magical about 9:30 and what was said or what was not said, within the context that we know it is alleged that this thing occurred in the afternoon. But it is incumbent on me to make a clean breast of what happened on the 14th. So page 147 tells us why I had to be in Mthatha at the very latest at 9:30. There was an application for leave to appeal. The parties had been directed to file heads of argument. Then things were specified. We all know that heads of argument need not necessarily be filed in an application for leave to appeal. But from time to time, judges issue directives calling upon parties to issue heads of argument. Sometimes because you want to hear them virtually, or sometimes you want to hear them by way of heads of argument without any oral argument. But in this instance, there was an application for leave to appeal to be heard on Monday, 14 November at 9:30 in the morning. What happened then at 9:30? We had dispersed, by the way. We left the meeting towards 9:30. The understanding was that because there was a bit of heated debate, and the meeting thought that the judge concerned and then ADJP Dokota should meet the judge concerned so that she could ventilate her problems in relation to what she believed she was being refused. So 9:30, this is what happened. So when perusing the documents before I got to Mthatha, I picked up that there was no compliance with my earlier directive. So let's read at page 149, Chairperson and honorable members. The application for leave to appeal is removed from the roll of 14 November. So already there was non-compliance with a previous directive. But then the applicant for leave to appeal is directed to compile a complete and paper record of the trial proceedings. It's clear from a reading of this. When I was setting out to prepare for this day, I found that the papers were what I believe a chairperson has heard before. It's normally referred to as dog's breakfast. Within the context of the court, judges have said this when papers are not in order. So when perusing this file, I picked up that the file was not in order. So I directed the way I did. Then already when this was issued, I can't see the second page. When this directive was issued, I knew that the matter would not proceed at 9:30. That is why I said the parties are directed to attend a case law management conference at the JP's Chambers Mthatha on 14 November 2022 at 9:30. So 9:30, that is what I was supposed to do. Let's talk about tea time at 11. In Mthatha, the tradition is that Work is allocated to judges before Monday. 9:30 court starts. Anything happens in court, cases collapse or not collapse. But the tradition was, ladies and gentlemen, let's convene meetings at 11. So on Monday, especially on Monday, so that whoever's case has collapsed may declare their availability. So that's what normally happens at 11. So that's what happened. Shortly thereafter, I'm not sure whether it was 11:15 or 11:30 or around about that time. That is when this event about me commenting about the complainants attire, that's when it happened, around that time. So it was in the morning. So the meeting involving the judge concerned took place just before lunch, around 12:30 or 1:45, but it was not a lengthy meeting. It was a meeting involving me, Tokota ADJP, the judge concerned, and some interested judge who had come there to be part of the meeting. So when the judge concerned got there, she adopted the stance that she was no longer complaining. She was no longer concerned about being not paid when attending conferences such as Saula and so on and so forth. And we left it at that. It became incumbent on me to report to judges on the following day. So here am I, lunch hour. I left for lunch, but in the course of getting myself money, I do remember that I had a card. So when I inserted it at the ATM, I had a problem of mixing a number because we deal with these codes 246810 or 5789 and so on. So the card, I think, was swallowed. And then I had to go to the bank. I have had to trace my way back in relation to the 14th because all of a sudden we've had to deal with the 14th. After the passage of time, I managed to lay my hands on things, objective facts that will at least shed light in relation to what happened on the 14th. So I was there at the bank, I was attended to, I left the bank and got back to chambers. Let's go to page 150. 150 is the tracker report for the 14th. We now know why I did not request that tracker report initially. The case that I had been called upon to meet was about the 15th. When there was an element of vacillation, I had to trace my way back to the 14th. So this is what I got. This document is to be held in this fashion, not the usual way, but this fashion. I'll count 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22. JJL 482EC, it's obviously a government-owned vehicle, tag not present. 1514 Errol Spring Avenue, Mthatha. Errol Spring, that is where Standard Bank is located, Beating Gaps building. I hope you found it, Chairperson and honorable members. I know it's not going to be very easy, especially...
Well, I haven't found it.
You haven't found it?
I have not found it.
Oh, all right. So, Chairperson, are you holding this document
JP,
this way?
I was just wondering if I need that.
We need it.
I don't know. Do we need that information?
Do we need that information? Yes, we do.
Yeah, take me to 21.
We do need this information. Page 150, This is the tracker report that was generated in respect of the 14th. Remember, I had generated one in respect of the 15th,
Chair,
but
can I give you which is marked already?
Maybe you
It's the
can
same page.
count from bottom.
Okay.
oh yes,
To
that's
be
the
nearer
best.
from the bottom.
Yes, that's the best. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 from the bottom.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yes.
So, JJL 482 EC is the car that I was driving. At 15:14 on 14 November, that is the time when I left Errol Spring Avenue, Mthatha. That is where Standard Bank is located, BT Gaps Shopping Mall. That's where it is located, 908 Errol Spring Avenue, Mthatha. And then 15:20 on 14 November, 15:20. That is when I arrived at 64 Leeds Road, Mthatha, which is where the court building is. I'm realizing I'm a fast driver. It took me a very short period to leave beating gaps to get to Mthatha. Anyway, I got to the parking lot as indicated there at 15:20. That is when I arrived at the parking lot. I would have parked my vehicle, moved upstairs or used an escalator to my office, which would then give me something like 15:30 when I arrived at my chambers. So when I get there, I'm told the lecture on default judgments will take place. The people concerned would still love to have you address them on default judgments. So between 15:30 and 16:15, and I must confess, as far as I can recall, that is the position. So for that period, I was in my chambers. From time to time, I was still working on this article that I'm very proud of, which was published in the Obiter, the NMU Law Journal. Intermittently, I would work on that. I didn't have to prepare for the lecture because it dealt with broad things. So I am led to a court. The court is full to the brim of attorneys to be addressed by me. I am led to that building, to that courtroom by Ms. Ngai. And indeed, in light of the fact that the case, the leave to appeal had collapsed, so it meant that there was no need of her on the following day. I released her. She's testified about whatever happened. I'm not privy to everything, but I'm just saying it is indeed so that I released her because the only thing that was outstanding was for me to give a report to colleagues at 11 on the 15th about the meeting that was held in my chambers. So in the afternoon on the 14th, I went into Court A, I addressed attorneys. I then left around 15:15 or 6:30. Then that will be 18:20, there it is. 64 Leeds Road, that's when I left. To where I put up, which is 68 Cumberland Road, Mthatha. And it took me about 5.3 minutes. Of course, it's not far from the courtroom. So I did address attorneys on default judgment related topics. I have demonstrated to the tribunal that for some other reason, this thing about default judgments had become a thorny issue. And when I finished the lecture, I discovered that I could no longer use my fingers to open. Actually, even the court door had shut me in. So I went out through the main court door, went to security officers who accompanied me to my office. I picked up my bag, I left. That was on the 14th. On the 15th, I was in my chambers in the morning, waiting mainly for the 11 o'clock meeting. Indeed, at 11, I met judges. I gave them a report that whatever thorny issue there was on the previous day, it has been resolved. At 12, I left. I've already pointed to the tracker report of the 15th. I believe it is relevant because a determination has to be made on this crucial issue. So in a nutshell, that is about 14 and 15. Let me reiterate that on the 14th, the only time I met Ms. Mengo was when we interacted about her dress code. That was the last time I saw her. Chairperson, with your leave, I see it's going for 1 o'clock, but I think it is incumbent on me, and this is something I will deal with when I leave this topic. It is incumbent on me, at least for now, to refer to the testimony of Ms. Mengo relative to what happened allegedly on the 14th, side by side with the CCV footage, notes, Exhibit 5. Alternatively, I might just request that that thing be played there so that I make my comments, but I will juxtapose that with what was said by Ms. Mengo in these proceedings relevant to the 14th. Could I be afforded the opportunity to break a bit at this point, to take a break, so that I deal with that when we resume, which will be the last aspect, I believe, relative to 14 and or 15 or 15 or 15, whatever the case may be.
I should hear from Mr. Sikakani
Yeah.
and not from the witness.
Thank you, Chairperson.
Yes. Chair, thanks. I think it's the right time. As you'll see, this is no ordinary witness, and I think it helps the tribunal that I do not interject with questions. This is a judge president. He can do so. I'm going to approach the next one in the same way, where there are themes, and I think it's less disruptive than me interjecting with questions. So we will deal with the next themes. He'll finalize this point, and then we'll deal with the next themes. And with your leave, I would suggest that we break now and deal with the next 2 or so themes. Thank you, Chair.
Let us come back at 1:45. We adjourn now. JP, you are still under oath.
Thank you for the reminder, Chairperson.
Yes. Mr. Sikakani.
Thank you, Chair. May I just request as we round off this topic of the 14th or 15th, ask the tribunal to get what was called Exhibit 4. It's a layout. If you could be given that, and Exhibit 5, which is the notes that my learned friend, Mr. Matonsela, placed before the tribunal. It's the notes on the footage.
Yes.
And
We
Chair,
have it.
Yes. Can I also say, Chair, I'm going to read, the panel doesn't have to go there. I'm going to read from the the record, which is the complainant's evidence in chief. It's the hearing of the 20th of January 2025. You could just note. And as I did before, Chair, what I will do is to point those things out, and in every theme as I will do, and allow the witness to fly on autopilot on each of those topics, because it makes it easier. JP, can I take you to that first and read you what the complainant says on the 20th? And so that you can help the tribunal compare whether the version is the same. It's at page 65.
Which is page 152 of the consolidated.
Yeah. 155 of the
152.
152 of the document that we did to make things easier. Ms. Mengo says this. Are you there, Chair? No, I'll wait. 152.
It's 152 of the bundle, on the strength of which I testified in the morning.
Yes, Chair. You will see the points that it says, and this is what the complainant says. I was coming from the chambers of the judge that I was working with. He heard the footsteps because it is not a mat there, it is tiles. He called me to come into his chambers. And then after being asked, she also says, no, he called out, in other words, he called me out, and also not in a loud manner or loud voice, because the judge's door where I had worked in is not far from his chambers. And then you will see that right at the end there, this is where she ends by saying that the respondent, the JP, said, do you see how much effect you have on me? I want to stop it there and put my witness on autopilot about comparing. We're going to take now both exhibit 4 and 5, and ask the JP to take us through those two.
Thank you, Chair. So a version has been proffered.
Could you just wait for the JP? I think JP is Chair is still reading.
Thanks.
Okay.
Thank you, Chair. So, Council, I take it that you were reading from page 65.
Yes.
Of the
transcript of
which is
the
page
20th.
152 of this document.
The document
that has
consolidated.
been consolidated.
Yes.
The point being made there is that she was coming from her chambers. So I will need to be aided with the map. I don't have a copy. So one must look at this testimony against the background of what is embodied on Exhibit 4. Exhibit 4 being the map. So,
just a minute, is this one?
Yes.
And that black stripe must be on the left-hand side, am I
Yes.
right?
Yes. That's
the dark, yes, the dark shade is on the left-hand side, Honorable Member.
Yes.
So, as I understand it, she says, and we will see that there is a chamber somewhere. Actually, yes. So there's an arrow which goes down, and then that arrow turns to the right on Exhibit 4. So basically, we are moving from the premise that, according to the testimony, she was not called by me as I was standing on my door being the one at the corner, as you look at this, which says rectify SI or something like that. So there's the door. I'm trying to make sense from this document. Yes, new judge's chambers is right at the corner. So it is not her testimony that I called her while standing on that door marked B1.10. So she claims to have gone down this way. I was from the chambers of the judge that I was working with. He had the footsteps because it is not a mat there, it is tiles. He called me into his chambers. Then she then says later on, she came back. In other words, the way in which she went, she then turned back. So it's either I called her while standing on my door, that is not the evidence. It seems from what I gleaned that I might have called her from the chambers of my secretary, not my chambers, but I'm just being benevolent there, Chairperson. So I would like us to look at this testimony in the context of Exhibit 4. But then, most importantly, we need to go to Exhibit 5. Is Exhibit 5 the footage? Because at this point, I would then say, let's look at this testimony. Let us have a look at the footage, but I'm covered by this exhibit. Thank you, sis. This is Exhibit 5. Exhibit 5 is CCV footage in Ray Mtata High Court corridor on 14 November 2022, notes on movement of people. I hope the honorable members have laid their hands on, and the chairperson too. Thank you. So we don't bother ourselves with what the introduction is about. We don't bother ourselves with the morning session of 14 November, for present purposes, of course. Then we go to the second last page of that document. Footage 2, afternoon of 14 November 2022. It reads, Ms. Mengo is seen emerging at the corner coming from the direction of Chamber 9. She's walking down the passage in the direction of Chamber 0. She's carrying a tray with teacups in her hand. She is seen exiting the corridor through C01 door. So were the footage to be, the video to be played, we would actually see the complainant emerging as stated here, because this is a document that is the subject of agreement between the parties. Then paragraph 30, Ms. Mengo is seen entering the passage again through C1. So in other words, she went in that direction and then she came back. Is seen entering the passage again, C1 door, ushering two individuals into Chamber 1. She and one of the two males enter the AJ's office. So that's not my office. Later, Ms. Mengo is seen coming out of Chamber 1 and exits through the door, C1 door. She does not feature again beyond that point. So in other words, if we look at this that was agreed to, unless we must replay it, there's no time when in the afternoon, Ms. Mengo is seen moving in the direction of my office, be it entering through the secretary's office, Ms. Ngai, and coming back the way she testified. Counsel.
Thank you, JP.
So the version testified to on the 16th, on the 20th rather, as you pointed to, that version does not find support from the footage, CCV footage, the video that was played. And in fact, if one has recourse to page 21, which is paragraph 20, where she says, a day later, he sees me walking down the corridor and imitates how I walk. So it must be that there was a time when, as she was moving down the corridor, according to her sworn statement in the complaint, that there's a time when she was walking down and then I imitated her walks, according to what I'm reading. I didn't comment, I walked past instead. On my way back, Court's floor in Umtata is tiled, so you ought to hear one walk and so on and so forth. I noticed that his secretary was not in her office on her way back. Got in and he showed me his trousers and so on and so forth. So this version, which is embodied in the complaint affidavit, in any event concerning the 15th, and her testimony fly in the face of this document, which is Exhibit 5. So it would be interesting to see exactly what her version really is. But some of the things are matters for argument. But point of substance is that this document embodying agreement as to movements does not support her version. I am coming to this tribunal saying I parked my vehicle at the parking lot at 16:20 as shown in the report. I walked up, I must have gotten to my office around 16:30. So, counsel, I believe that disposes of the incident of 15 or 14 or 14 or 15, whatever the case is.
Thank you, JP. Chair, as you'll see now, I'm also going to then move to the chats. But what I'll do is to start with what I said. I separated it as a theme because it's been a recurring theme of one more allegedly disgusting thing that the JP did, which is what is known in the annexures as in the picture as K8. But may I take the in this document, document that you were given this morning, page 19, because I think
Page 19.
19. The starting point should be what the complainant says in paragraph 15 thereof, which is her complaint about this event.
Thank you, counsel.
And yet again, as I said, I think it's much more useful to put the witness on auto cruise here. But to read the paragraph, it says, it's well, 1, 2, 3, 4, 5. It's the 6th line on that paragraph, page 19.
Page 19.
It says, JP sent me an image of private parts and asked me, quote, yours please, close quote. And I replied, Jesu. He said, why? Does it look delicious? I did not respond. And that is reference to annexure K8. It's at page 51 in this document. That's K8. JP,
Yes.
may I give you the opportunity to deal with this question before we go to the general chats?
Thank you very much. Chairperson,
It's just a
Sorry, Chair. Yeah.
Chairperson,
In the complaint, it's page 47. K8. Yours is page 50. It's
Is a page, small page 50, and then big.
could I
60.
assist?
yes.
So the journey that we are undertaking now, Chairperson and honorable members, is the journey around K8. So council has referred to, as a starting point, the complaint itself. The complaint he has referred to deals with what allegedly happened on 20 June, I suppose 2021. Could we then go to page 18 of the document, page 18 of the document that I was using in the morning, where everything is put together?
Page
page 18. I want to start where it says on 20 June. So the document that we are about is the one that we were using in the morning, Chairperson. The question now relates to K8 and what is said about it. So paragraph 15 is at page 18. I hope the chairperson has laid his hands on that.
Paragraph 15.
Paragraph 15, page 18.
Oh, I see. All right.
Small 15.
Okay.
Yeah, small 15.
Small 18.
Small 18 as against 31. So paragraph 15 mentions things that allegedly took place on the 20th of June 2021. So the aim here is to refer to the complaint itself insofar as it addresses K8, is to refer to this other bundle, which is Exhibit 3, and for us to trace what it is that is said about K8. As a starting point, I never sent any private parts picture to the complainant. That's just a broad statement, but now pertinently I'm dealing with K8. So paragraph 15 starts off by saying, on 20 June, he commented on the voice where I was sitting with my sister's kids. And then that paragraph ends with her saying, he sent me a video of a woman lying on her back with a man on top. We'll deal with that in a separate topic. Then we go to page 19, Chairperson. Page 19 has got 1, 2, 3, 4, 5 unnumbered paragraphs, all falling under paragraph 15. Counsel referred the tribunal to the third one. JP sent me an image of private parts and asked me, yours please, and I replied with Jesso. He said, why, does it look delicious? I did not respond. Then she says, see K8. So how do we get to K8? We go to page 50 of the very same.
Before you get there, you lost me.
Shall we go to page 19, Chairperson? Page 19.
Yes. Page 19.
Page 19 on top, small 19, as the chairperson found it.
Yes.
So you count 1, 2, 3. JP sent me an image. Does chairperson see that?
I do.
Yes, thank you. JP sent me an image of private parts and asked me, yours please, and I replied, Jesso. He said, why, does it look delicious? I did not respond. Then she says, see annexure K8. So we know now that in her complaint, she is alleging that this is what happened on the 20th of June. Let's go to page 50, please, Chairperson. Page 50 of the same bundle that you are paging, Chairperson. Page 50, on top, small 50. Reference is made to that. All we see is 0905 at the bottom on the right-hand side, nothing else. That's what we see. Then, dealing with K8, I would like us to move to the exhibits bundle on the strength of which Advocate Skeppers led the witness. Particularly page 1200.
So it's volume 3 in other document.
Page 1200.
JP, could you just stop while the tribunal find it?
Thank you, Counsel.
It's just pictures. It's the consolidated pictures.
Yeah, Exhibit 3 is actually the document that was used by and large by Advocate
JP,
Skippers.
just hold on. We'll show them. We'll show
Okay.
them. They'll find it.
What page is it?
1200.
Thank you.
Council,
Yes,
shall I proceed?
you can proceed. Thank you.
So at 1200, Chairperson, is a reflection of the events of 20 June. But we went straight to, 17 June. 17 June. I want us to start there. These are events of 17 June, actually, not 20 June. So, in her testimony, she says, I sent her my private parts with white hairs, and I was standing above a toilet cubicle. What is happening at page 1200 is a mere chart, and I will deal with it, Council, when I, on my own, for the sake of expediency, go through these charts with your permission, autopilot or something like that. Yes, but I'm saying the first reference to K8, according to her testimony, is what is said at 1200, which are events that took place on 17 June, according to the testimony. So we have it there as something that occurred on the 20th. Mention is made of K8. Then, closer to what we are talking about, and Council, I may have to traverse this within the context of the charts, but I'm dealing with your pertinent question now.
Yes.
1220. 1220 is at page, is 1220 of the exhibits, of exhibit 3.
1220.
1220.
It's, can I make it easy? It's of volume 3. I think she's got that far. It's volume 3 as well. Yes. It's this one, not our document. It's the downloaded pictures. Thank you. You may proceed, Jim.
Yeah. So what is appearing at page 1220 is what is testified about or testified to in the affidavit that we pointed to, which is paragraph 15. There's just one thing that I want to mention at this point so that there's no confusion. We see from page 1220 that these charts allegedly took place at 22:58 See, at 1220, it's 22:58. She says she had said bye in her testimony, and then I sent that, and that K8, and then she said Jeso there too. So 22:58 is the time. Let me put it like that. But then if one goes to page 50, this creature, page 50.
That is of the consolidated document now. The other one, the file that we gave you this morning.
This morning.
Yes.
Oh, 50, small 50.
Yes.
Yes.
You'll see there's 0905. So, however this picture was generated, but it's got 0905. Yet it is said to relate to a conversation that took place at 22:58. That's just the point I want to make, Council, at least for now.
Yes.
This picture at page 50 of this document that has got this alleged private part, page 50,
Yes.
has got 0905 on the bottom right-hand side. It is said to relate to a conversation that took place on the 20th at 22 hours 58.
May I ask you once again, JP, because this has been probably the biggest headline.
Can I just stop there for a
Okay.
while? I was trying to finalize what you are
Okay.
saying.
Yes.
Or you say yet is said to be related to a conversation.
Yes.
Which conversation?
Let me repeat, Chairperson.
Yeah.
The complaint, paragraph 15, something that we referred to, the complaint, the affidavit setting in motion the complaint about which we are, says something about what allegedly happened at 1220. The conversation is at 22:58, according to what appears at page 1220. The conversation is at 1220, and the allegation is that K8, in the midst of what was happening at 1220, in the midst of what was happening at 1220, K8 was transmitted. I'm saying if we go to K8, we see something with 0905 on the bottom right-hand side. So I'm saying when it comes to times, there's an incongruity. Apart from all else, the notion I'm developing here is simply that a conversation, it is common cause, took place at 1220, page 1220. This is what the complainant is addressing in her complaint. So that is one version.
And the time there?
The time there is 22:58 at 1220, at page 1220. The time is 22:58.
You contrast that with the time depicted on small page 50,
Yes,
0905.
It doesn't tie in well. 0905 is clearly in the morning. 22:58 is something else. Insofar as, in fact, there is such a thing as page 50. I'm just pointing to a few incongruities or inconsistencies. So we are told about K8 at page 1220. And then the narration is about what happened on the 20th of June. And we see that what was happening was an interaction around 22:58, 22:59, and so on. Yet reliance is made on a document depicting a picture that bears 0905. That is the only trace on this document as to time frames. We don't know where it comes from. I'm not an expert. There's somebody who testified to this. That's K8. But lo and behold, at page 1220, at page 1200, 1200, of this document. This one that says got BJ, not to worry about that, length, okay. Bendise busy, ukolo. That is the page 1200.
Yes, JP?
Now, what is interesting is, what is narrated at 1200 is on another date. What is narrated at 1220 is another date. But K8 seems to be a denominator. So there are two instances when K8 was allegedly transmitted. Now, Chairperson, when I deal on almost a line-by-line basis, when I narrate the story, I will harp on this. But I was simply trying to answer the pertinent question raised by counsel in relation to K8. Just to say this, that at page 32 of the transcript, when she was testifying, she refers to K8.
That's on page 19, JP.
Thank you, counsel. Page 19 of the testimony.
Page 19 of the testimony.
Now, page 32, as she narrates events about or around K8, there is reference at page 32 to K8. Now, this is a separate occasion. Then,
JP, you are losing me. You mentioned page 19 and page 32. Which page are we at right now? Don't lose me.
all right, let me first start off by saying the intention is to deal with these annexures and what I'm said to have sent when I deal with the charts on a date-by-date basis. But for now, I'm responding pertinently to a question relating to K8. I am saying,
JP, but I think you've lost my colleague because you're referring to page 32, which is actually page 19.
19.
Yes. I
Of the
think
transcript.
if we're working on this bundle's numbering, then it is page 19 and not 32. Am I
Not,
correct?
not what, honorable member?
You referred now to page 32, but I think you mean
Of
page
the transcript.
19 of the transcript.
Yes. Yes. I'm just saying at page 32, he refers to K8 when she was narrating her story here at the tribunal. So maybe, counsel, with your permission, let me rather on my own narrate the events.
Yes.
But in answer to your question pertinently, K8 features on more than one date. That's all I wanted to convey to
But
you.
what are you referring to? Are you referring to the printed 19 or the written 32? That's what I'm trying to get.
I am talking about page 1200 of Exhibit 3.
Yes, we've got that. But now, what on your bundle? Which page are you referring to?
This bundle of today.
Yes.
No, this bundle does not deal with K8 in the context of the testimony. So, counsel is asking me, tell us about K8. I say I never transmitted K8. I'm trying to demonstrate that K8 features on more than two occasions as something that I sent. But perhaps for the sake of convenience, with your permission, Council, let me rather narrate these facts because somehow,
Let me ask you this, JP. So let's bring this to a halt. If we left the contradictions and how many times it's repeated, what do you say to the accusation that you sent that picture reflected as K8 of your private part or any picture of a part of your body?
thank you, Council. I never sent K8. K8 has nothing to do with me. I never sent H1 and H2. I never sent to the complainant exhibits P and exhibit N and any part of my body to her. Any picture of my body to her.
Thank you. Chair, we're going to now move to different sub-themes of the chats. And we're going to use volume 3. The one, yes, that's the one that you had of the pictures. And the dates.
So, sorry, just before we leave this point,
Thank you, Chair.
are you saying that K8 was referenced to in more than one instance?
Yes. I'm going to demonstrate that.
Yes. And are you also saying that the time at which the time appearing
On K8
is not consistent with which time?
with any one of the allegations made by the complainant
About K8.
about K8. Firstly, based on her affidavit, and secondly, based on her testimony when she was here. That is what I will seek to demonstrate.
Yes, no, I got that. I think we are clear with that.
Thank you, Chair. Chair, just for convenience, the sub-themes on the charts we're going to deal with, they're in volume 3, and they will either use the dates or the pages. But they start at page 1156. It's going to be the very first page in that document. To 1181. It's the chart of 8 to 9 June 2021. So that is where I'm going to unleash the witness again on auto cruise.
From which page?
It's the very first, it's 1156. The date is 8 June at the top. And JP, I want to ask you this question before we start. Apart from the issues that you've disputed, and I'm not talking about interpretations that have been given by different people here, did the chats, apart from the ones you've disputed, did the chats take place?
The charts as embodied in Exhibit 3, which we'll be journeying through, did take place to the extent that they take us right to page
You don't have to go there, JP.
1270.
That's fine.
Page 1275.
Are we in the same volume?
Yes.
Exhibit 3.
It's volume 3. It's this.
Okay.
It's not an exhibit. It's volume 3.
Volume 3. Thank you.
Okay.
Yes.
Shall I start narrating the story on a theme-by-theme basis?
Yes. Between 1156, page 1156 and 1181 is the sub-theme where the chart is about the exchange of pictures. You
Thank you
can
very
start
much.
narrating from the 8th to the 9th.
Chairperson, I'm now giving my version in relation to pages 1156 to 1181. I would like to prefix it by saying that, but for this document, I would never remember every and anything that was exchanged between the complainant and I. This has been very helpful to me, and somehow, when I address the tribunal, I make it clear that my understanding of what I'm reading here is what it is, and so on and so forth. So, 8th and 9th June 2021, starting at 11:56, this is where we start. Those are charts that took place on 8 June 2021. Right on top. I'm not going to read line by line. I will try to skim through and deal with things that are of significance. Somewhere I will deal with, for instance, allegations that there was a rebuff. I will indicate where there's no rebuff. And in fact, as part of this exercise, I will be showing that, contrary to what has been said about there having been 12 no's, 12 not noses, but 12 NOs, I'm going to demonstrate that that statement is not accurate. So this exercise, I submit, is very important in that I may deal with quite a number of topics under it, because there's going to be a problem if we have to, there's going to be toing and froing, putting this document aside and going back and so on and so forth. So that's why I'm saying, let me go through this document. What we will see at 1856, at page 1156, the discussion emanates from me having met the complainant at her chambers and having conversed with her. This is where she says, "Thank you, Judge, but I don't understand what we talked about. I'm grateful for the fact that you respect my child." You'll recall that she did give testimony about our interaction in her office at a time when I had visited her, Judge. So I respect everyone. Then there was that emoji, much obliged. There is nothing really of significance even at page 1157. So I say at 1902, "So how many kids have you been blessed with?" She responds, "Only one." Then I say, "Oh man." Then I say, "Girls look after their parents in later life." She responds at page 1158, "Indeed." So, oh yes. Then she says at 1904, "Oh yes, she has started already." And then I say, "You hear that? What is her age?" She is turning 12. I'm at 1159 now. And then I then say the age difference is 16 or 18. And then I put this emoji with a monkey closing its eyes. Likewise, laughingly, and with the same emoji, she says,
JP, can I just ask you to slow down and indicate what time you're talking about when you mention so that the tribunal can follow?
Thank you very much. So at 1905, Honorable Chair and members, did you really calculate that? 1907, after laughing, I say, "Sendi Buzanje, I'm just asking." Then she says, "I'm 37 years at 1908. Then I exclaim, and then she laughs at this with that emoji. I'm saying, she asked me, "Am I old?" Then I say, "You look much younger, nelizwi lelo sana." The voice is similar to that of a younger lady. And then at 1910, at page 1160, she says younger, not older. Kukuziphatha kakuhle. I behave well, or I handle myself well. Ilizwi, then she laughs at that with this emoji. I say lincinci ilizwi. Then she responds at 1910. Then I say, when first I had it, I couldn't believe. Then she says, "Carry on, I'm listening." This is how I interpret what she's saying. "What do you mean, kukuziphatha kakuhle?" I'm asking, What do you mean that you are behaving well or you look after yourself? Then, other than what is asked at 1912 at page 1161, there are these eyes and the ear. I'm interested to hear more on this subject. She says, I maintain myself well. Exercises keep me younger. Then I say, keep it that way. She then winks at me at 1915. And then I say, Nzawukhe ndiyijonge. I will consider it. Then that takes us to 1162. Then I ask, prove your age. In other words, I'm saying, how would you prove your age? This is a chart at 1919 at page 1162. Then the response, in my view, is of significance. She says, Nguwe ofuna ukuyijonga, my part would be giving you a task. You are the one who wants to consider me, but my part would be to give you a task. Then that takes us to 1163. To ascertain the content, I ask, come out clear how?
Just a minute.
At page 1163.
Moving over to 163, yes.
1163, at 1923 and 1924, she responds to my question, how? She then says, a chance for you to look at. Then you determine what you are looking for. Then you determine what you are looking for. Then I say, it's not easy, hey? And then in response at 1925, we've got this monkey covering face emoji. Then I say, truth be told, I have no reason to doubt your word. Then, now that's 1925. Then that takes us to 1164. She then says, that means a lot. It's hard to trust these days. Then there's an invitation. Now, moving forward, I'll be talking about requests for pictures and talks around those things. Who sent who what picture? At the level of this chart, which Council has mentioned is a chart of 8 and 9, June 2021. At the same time, I will be pointing to the fact that there is no rebuff at the level of us exchanging or talking about the exchange of pictures. That is what I will endeavor to demonstrate.
164, what?
1164, page 1, at 1927. Then I say, notwithstanding the fact that I had said, truth be told, I have no reason to doubt your word. Maybe a few pictures you send may serve as halfway proof. Then that is a pertinent invitation by me directed at the complainant on the topic of pictures, which is what we will be delving into in these next few pages. Maybe a few pictures you send may serve as halfway proof. 1927, 1928. Then, what is their response at 1928? I will try to take more pictures, but currently I lost the most. My phone deleted everything recently. All I wish to highlight is that there is no response that, no, you are not going to get pictures from me. On the contrary, there is a statement that says, I will try to take more, but currently I lost most. My phone deleted everything recently. Then at 1929, I used the magic word high. In other words, for me, when I say high, it was in disbelief that she lost everything. But then I also say at 1930, I'm kidding. Then at 19:30, she also says, cool. Then I say, send me few that you've got at 19:30.
May I ask you again, JP, to slow down a
Thank you.
bit for the tribunal? Thank you.
Thank you, Council. Sorry for the speed.
Yes. We are
So we're
now,
still at 11:64. I have mentioned that the response is I will try to take some pictures and so on. Then 11:65. In pursuit of what I had said earlier on, I said, well, few that you've got, the answer is will do. That is not a rebuff. I will do that. She says that at 19:30, at 11:65. So on the issue of pictures, I will do. Then at 1932, I've got all those emojis there, the one about eyes, the one about tongue sticking out, the one about monkey closing its eyes, and the one with arms on the head. And then at 2017, there being no response from her, I then trigger interaction by saying, hi, you are silent, Chwaka. That's what it means. The response at 2022, once again, is not that I don't like this idea of exchanging pictures with you. On the contrary, she says, oh, buzifuna kwangoku na, oh, you wanted these pictures now? Uxolo, sorry, bendisajima. I was busy exercising. There's a term where they say you read the room, you read the room. In other words, you ascertain what's happening. Then in ascertaining her comfortability about this interaction, I say if it won't offend, I say that at 2023. And then 2027, I expressed something about the fingers there. I'm saying it would be good if it won't offend. So it's not that I'm riding roughshod, talking to the complainant without engaging her. Her response at 2028 is to wink.
I stop you there, JP. What was your understanding of these chats up to this point? What was your understanding of the wink?
In particular, I understood the wink as somebody who is happy to interact with me on this subject. Winking could mean winking in the true sense. When somebody wink, if I were to step out of this room and a lady were to wink at me, or put it this way, I were to wink at a lady, she would know that there's something about that. But I'm just saying she was winking, and my understanding of that winking was, in broad terms, she was just happy with what we were talking about. Winking is flirtatious.
Apart from this wink, JP, up to so far in your conversation, was there any point at which you doubted whether she was rebuffing you or uncertain or uncomfortable?
No.
Thank you. You may proceed.
2028. 2028. I say, wow. Now, when one says wow, there's an element of admiration or awe in response to what somebody does. And allow me, Chairperson, to venture and say, this must have been a response to a picture that she sent. I could never have just said, wow, from the blue. But I'm going to develop this point. Bearing in mind that when one deletes and insofar as I had been deleting for reasons that will be mentioned, it shows here that Mbenenge deleted. But there's something very strange about the complainant's side of things, is that she does not only delete, but she even deletes the reference to deletion. I'm going to develop that theme within the twinkling of an eye. So I say, whoa, at 2028, and I can't think of anything other than that she must have sent me a picture, and in admiration I said, whoa. Otherwise, I wouldn't say whoa to somebody just winking at me, flirtatious though it is. Then I say kulula umtla, clearly that related to a picture that had been sent. When I say kulula umtla, take off your garment or your jacket. Then she responds laughingly, Aziko will try later. I don't have, I will try later. Then I say, please, that is at 2029. So at page 1166, we can only jump to 2028 by way of time. That's where she says, Aziko will try later. That's 2020. Then says, please, for that assessment, which assessment? The issue about age that we were flattingly talking about. Say, please, for that assessment. And then, poof, 2032. I say stylish. I was addressing the complainant. The complainant had clearly sent me that picture. It was not a status picture. It was not uploaded from her status. It was a picture that she actually sent to me. I say, with this indication, stylish, which is compatible anyway with. And then I was admiring.
Where are we now?
We are at page 1166 at 2032.
At what time?
2032.
Mm, 2030.
2032.
Mm.
That is the that is
PP, can I ask you this so that they follow? Why? Two questions. You make the point that that's not a status picture. Could you explain why you say that and how you say that?
because if we take a picture at random, for instance, at random, let's go to page 1223. And there are many of those, just at random, 1223 of the same document, to show how a status picture commented on looks like. Chairperson, this is a factual issue in relation to which a conclusion could be made with relative ease. Page 1223, could we go to 1223? This is where I demonstrate that if you comment on somebody's status picture, then it must have you status. This one is you, a photo that she sent to me, not uploaded on a status. She did send a picture to me. That is signified by me saying stylish. But then the problem is we don't see her deleting this, to which I commented stylish. We don't see her do that, which then means she must have deleted that picture. She must have deleted the reference to deleted. I'm going to develop this later on, the way I understood it and the way I see it. So in any event, stylish, this is me commenting to a picture that she transmitted to me, not a status picture that I commented on. I do from time to time comment on her status pictures because as we were conversing, she would be changing status pictures from time to time. I do comment on those. As we go on, I will be indicating. But one thing that should be emphasized here is this is a photo. It is sent to me by the complainant. And when I say stylish at 2032, I'm commenting on the picture or on a picture that she sent me. So that takes us to 1167. After I had complimented her and said stylish, she too responds at 2033, you got a fine eye too. So stylish, you got a fine eye too. And then when I say for final assessment, which I said earlier on, at 2033, she comments to that by closing her eyes. A monkey closing eyes. Chairperson, we've been talking about this emoji, the one of a monkey closing its eyes. I must readily confess that I am not proficient in the emoji language. I don't have a doctorate on this. I studied English, Afrikaans, and Xhosa up to matric. I did English in my junior degree. I did Latin in my senior degree. So when it comes to emojis, I am like a person who processes things the way she sees them. And I want to address, maybe for the first time, this emoji about somebody closing their eyes or a monkey closing eyes. So I don't want to claim proficiency in emojis, but in my answering affidavit to the JCC, I made it very clear that I understood these emojis that she exchanged with me as being flirtatious. I don't need to go there now, certainly not at this point, because I don't want to mar the waters as I proceed to demonstrate the point that I'm working on. I am a Xhosa man. I would say in Xhosa ndingumXhosa. And I know of something like, on the part of a lady, ukumutsa. I may have my own interpretation of ukumutsa, but I'm happy that, Chairperson, you asked the interpreter to be around.
Maybe she could just tell us what that means
Yes.
from where she is.
We can get the spelling first, Chair. It's
Yes.
UKUMUDZA.
Okay, start again. You.
Mutsa.
UKUMUDZA. Ukumutsa or ukumutsa. Some areas will use the TSA in the end. But if I'm hearing the JP correctly, he's using the pronunciation of the DZA, ukumutsa. He'll correct me if I'm
No,
wrong.
sorry, interpreter. Actually, TSA.
TSA.
From
Right.
a Pondomise Xhosa perspective. I am a
Amampondo.
Pondomise and Ndingujola Istuko. We'll deal with Jola later on as we converse.
Thank you, Chair, for that. Thank you, JP. Therefore, the spelling will be the correct one now. UKUMUTSA.
I defer. Oh, sorry, Chairperson. Chairperson, I said something about ukumutsa. I did not interpret it. I defer to her wisdom in relation to that. I can explain what I understand to be ukumutsa is when you show interest in a lady and in the Xhosa setup, they don't look you in the eye. Bayamutsa. They look down. And when somebody covers face like this, for me, a Xhosa man, that is sufficiently flirtatious. I don't know what interpretation she has about that.
Yeah, give it to us.
I was about to interpret, Chair, and then the JP got in there. The interpretation, even though we will never really honestly have a direct translation, but the interpretation of that is indeed being flirtatious from a female's perspective towards a male.
Thank you, Chair.
JP, is this your understanding of what the two of you were doing?
Yes. At this point, the level was that of exchanging pictures. But I'm infusing this because through and through, there are these emojis, this particular one. And I thought, Council, I should just pause a bit and express myself in relation to that. I'm not good at that language of emojis. I defer to the wisdom of those who said something here. But for me, it is important for the tribunal to understand my perspective and that of the complainant within the context that both of us are Eastern Cape Xhosa speaking people.
On what basis, JP, then did you use? We understand you've said to the tribunal you do not know, most of us don't, what these emojis mean from the expert perspective. What was your understanding of the emojis that you used or that the two of you used when conversing?
As I will demonstrate later as we proceed, these were flirtatious interactions. And Chairperson, I could not resist but check what ukumutsa means. Not for any nefarious reason, but just to check. This is what I found when I Googled. A pretense of shyness or modesty intended to be alluring, typically used by a woman. I'm just referring to that as defined by Google, but the word itself is ukumutsa. And I'm not trifling with this tribunal when I address this aspect. I must say I'm at great pains to have to talk about chats between two adults, consenting adults. It is highly embarrassing for me to have to talk about this, but I am charged with this offense and I must put things in their proper perspective, that these chats were were not wanted and so on. So I'm addressing this particular one within the prism of an African, a Xhosa man interacting with a lady. And I'm shelving for a moment the terminological battle that was waged here by one expert, for instance, endeavoring at best to tell us, probably from a Western perspective, what that means. I distance myself from that. I am the talker here. I'm the one who is addressing the complainant. The complainant is addressing me. Therefore, Chair, I appeal to the tribunal to listen to me as I led by counsel, as I try to demonstrate and navigate this controversial chat, which, as I say, it's got embarrassing parts of it, chats between two adults, chats that were wanted, and no one in this room, if we were to say, let's take your phone, let's see what you were discussing with so-and-so, they may not be flirtatious, but anyone, Chairperson, who will have, at some point, I say, have to divulge what they were saying, either in the morning or last night. But here the context is flirtatious chats between the complainant and I, and it's something that's embarrassing. Maybe, counsel, it's opportune stage for me to say, these chats surely may have embarrassed many a South African. I don't doubt that. As they do me as I talk now. That is regrettable. I may deal with that maybe later on, but I thought I should address at 1167, this chat. Then when she says, I will try later, at 2037, I say, I will wait. And at 2049, realizing that I'm waiting patiently, I then say, robbed. Now, a lawyer interpreting the word rob will say, we'll go back to the criminal law class where we were told, Chairperson, that theft plus violence is equal to robbery. I think there was something like that when we were in our criminal law classes. But when the word robbed is used here, it is within the context of flirtation, udlala ngam. It was more to express something like, you have been waiting, and then the response to robbed, because rob from a Western perspective could mean quite a number of things. But what we see 4 monkey closing eyes emojis at 2050. Now, the reason why I address this at the level of this one emoji is because this type of emoji or these emojis transcend this document.
And what did they communicate to you?
My understanding was that the complainant was not only playing along, she was happy with the conversation. She never expressed discomfort, as I will show. Up to now, Chairperson, we don't have any no. We were told there are 12 no's. I'll deal with that in due course. So, at 2051, I say, we're still within the conversation of, because we are dealing here with flirtation, we are not dealing exactly with a romantic relationship. We're just dealing with a flirtatious relationship.
Could you explain that difference? You say to the tribunal it was flirtatious, not romantic. Could you
Yes,
make that
flirtatious is a playful way of interacting with a person of the opposite sex. It could be initiated by a female towards a male, but flirtation is an informal, joyful, playful way of interacting with a person of the opposite sex. Playful way. A romantic relationship is a romantic relationship. Maybe at the end of my presentation, Council, through you, it must be clear to all and sundry that this relationship never gravitated to a romantic relationship.
Sorry.
In the true sense.
Say that again.
This relationship was a flirtatious relationship with all the levels of flirtation. Some at a low ebb, somewhere, somehow it's deep. It borders on being romantic. But at the end of the day, as I indicated to you, Council, the intention was to have a romantic relationship with the complainant. So we're talking flirtation now. Chairperson, we are at page 1168, 2051, where I say, "Hayi man undiqhathile." In other words, you've robbed me. She responds, and this is this terminological gymnastic that is an interplay between the West and Africa that I'm going to deal with now. Her response is hayini, laughing. Chairperson, the little Sotho or Tswana that I know is something where I could score
Could you
5.
just give the time?
Sorry, 2051. When I say ndiqhathiwe, laughingly she says hayini, and I'm going to deal with that. Thank you, Chairperson.
Sorry, you were beginning to make your attempt at Sotho speaking.
Yes, I know that the Sotho, Tswana, and Pedi, somewhere, somehow, you find that there's a word that covers both, the 3 languages, but I've heard it said, and I may be wrong. You see, where she says hayini laughingly, it is still within the context of flirtation. It is not a rebuff. Let me develop my theme. In suit, it would be something like Hebanna. Is there such a thing, Chairperson? I've heard it.
Ask the interpreter.
Hebanna.
I am 100% Xhosa speaking, but I found myself saying, Batung.
Batum.
It is an exclamation. That's what I'm trying to say. The Ayini does not necessarily say no, but it's an expression of an exclamation.
All right. JP, let's speak
As
to
to
Xhosa.
Hebana,
I'm
I'm not certain. Chair.
Yeah, Batung. But I've heard Batung. I've heard Batung, by the way. I've heard Hebanna. Let me stick to Xhosa. When somebody says,
But sorry, the interpreter you mentioned, Eban. What did you say?
When it comes to Hebana, because of it's not my first language, but I've always heard colleagues when there's a particular conversation, out of being surprised or out of being shocked in whatever it is that we're talking about, then you hear someone saying, Heban.
Yeah, well, that's accurate.
JP, can I ask
I
you,
hear about Batung as well.
Yes.
is this an expression of annoyance?
Not at all. There are 3 laughing emojis there. In a conversation between a man and a woman, and I'm not claiming any expertise here, but I am an adult male Xhosa person. Within the context of an interaction, when you say hayini, and there is this laughing emoji, you can simply imagine somebody saying hayini and laughing at the same time. But this is not a rebuff. I am going to show why I say it's not a rebuff within the twinkling of an eye. And then at 2052, I say, unamaqhinga, which is, uyandiqhatha, which means, as I said earlier on, you are robbing me. Then she says, at 2052, uyabona ndiyenzile obuyifuna. You see, I've done what you asked me to do, which lends confirmation to what I said earlier on, which is that she did send me a picture. Uyabona ndiyenzile obuyifuna, and she does that laughingly. Then in response to unamaqhinga, she says, at 2053, end it.
What did you understand this to mean?
It is in keeping in our culture with somebody who is not going to necessarily express it, but as we know, no man in our culture will say, when I proposed love to X, they said yes at the outset. As I understand it, this is a game between a male and female.
Well,
They will start off by saying hi for that matter, and any married man here will tell us that, yo, wandisokolisa ke lo mfazi.
to mean?
Which means she gave me a hard time, this woman.
Now, I'm just talking about a married man on purpose. I'm talking culture now. I'm a Xhosa man. Even before you say end it, it is understood in an interaction where you show interest in someone that you're not going to get yes as early as yesterday.
JP, the expert made attempts at this point on all of these to give you advice about this, that at this point, she would have advised you, or you should know that the person is not saying yes or is not agreeing. You should.
That does not find support from the context of this interaction, which I've unfolded. I'm just saying, even if she had not said end it, it would be implicit in a conversation between a man and a woman, be it a woman who is eyeing a man or be it the other way around, that there's an element of ending it. So, but when she says end it, it is earth-shattering. Then it means I must roll my sleeves and prepare myself for this. things are not going to be easy. And it is an invitation. I couldn't understand it differently. I still don't. When a woman to whom you've shown interest says, earn it, it means earn it. Isebenzele.
Well,
I
all I
thought
was
that was
saying
the
to
word
you is-
that was used, misinterpreter. Isebenzele, earn it.
It's earn it.
But the expert was saying, forget that cultural prism or understanding of yours. By now, you should not have proceeded.
I don't necessarily appreciate the perspective of one from the Western culture imposing their thinking on us as Africans. In any event, if you are talking about the expert, Miss Lisa Vetten,
Yes, I am.
admittedly, she's never even been to the Eastern Cape. She never interacted with the complainant and I. She was just developing a thesis. I'm just talking from the perspective of being the person who interacted within the context of my culture.
Okay.
I defer to what she says. She may write books, such as many have done, but I'm wary of notions and concepts from the West that are imposed on us as Africans. So, 1169, earn it, you are tricky. That statement, in my view, is inconsequential. She laughs, but when I say you are tricky, she says, it's part of the task that I have given you. 2054, page 1169. Then,
What do you say to the interpretation imposed again that when you say to someone here, you are tricky, you are calling them a trickster?
not at all within our culture. The word tricky, for instance, even in common parlance, especially lately with Model C and all those things, does not necessarily impute trickiness of a trickster necessarily. When somebody says you are tricky, they are saying, well, I don't follow exactly what you are saying. I'm just talking in general terms, Johannesburg or East London or Umtata or wherever else. But fact of the matter is, when you say somebody is tricky, you are not necessarily imputing unbecoming conduct on them. Certainly not within the context of this discussion.
You can even speak of a tricky question
Yes.
in the exam.
Thank you, Chair. I am expecting that even in the courts of law, counsel who have now become very liberal, we will hear things like, my lord, the question you've put to me is tricky. We are soon going to hear that term being used. But I fully understand what the chairperson has said, and I fully associate myself with him in the notion that he is interpreting. So it says part of the task, you are tricky, part of the task. I am reminded here that, remember, your task is to consider me. Look at what you want from me. Now, any man seated here being told, ndijonge, ukhangele le nto uyifunayo kum. Could you interpret that, ma'am?
Look at me and find that which you want from me.
That would not only be flirtatious, but it would be, I submit, an advance by a woman. And even in the Xhosa culture, it's not something that can necessarily be looked down upon. Perhaps before I drown on these cultural issues, I'm not an expert. This is just me addressing the tribunal from the bottom of my heart. I'm trying my best to be candid in how I understood what was happening here. So part of the task, something I deleted, she then says, will do. In other words, chairperson, at 2055 at page 1169, if we go back to the earlier thing that I said, go halfway now, she still repeats, I will do. We're on the lookout for the 12th rebuffs. Is it 12 or 16?
12.
12. Then I allocate a mark, I say 50%. She expresses herself the way she does at 2057. I'm not going to repeat that. 50%, 1170. And then poof, at 2110, 1170. Yazi ba mna xa ndifuna imali uzawundinika. You see, in all this interaction, in all this request that you are making, you must also know that when I want money from you, you will give it to me.
What did you understand this the request or demand or statement to mean?
I understood this statement to be part of bargaining with me within the context of what we were discussing. You know, at a certain level, it's got to do with the fact that yes, I am not surprised that there is that emoji there where there is a monkey closing eyes, but she did express herself the way she did. And I understood her to be saying, well, let's be transactional a bit. You want pictures, I want money from you. I don't want to sound unfair towards the complainant and say she's a money monger. I want to use this within the context of flirtation and nothing beyond that level. I don't want to accuse her of being a money monger. It is for that reason when I say, life is not about money, she says, I know, or ndia posisa, she then says truth. So I don't want to read much into that beyond saying there was flirtation, and this hardly constitutes a rebuff.
Well, the complainant on this point, and I will take the tribunal, says she knew that by mentioning this, a man would run away. So it's a no, it's a rebuff. It's to make sure that you walk away from.
That's too presumptuous.
She says so.
Yes, I'm saying it's presumptuous for one to believe that. So sorry, I'm using my hands as if I'm pointing at somebody. So sorry for that, Chairperson. I don't want to necessarily agree with that when somebody says, if you want money, then you must know you will give it to me. I don't necessarily see that as a rebuff. I just see that as being transactional, as part of the flirtation.
Okay.
For that matter, persons who flirt or persons who end up in a romantic relationship will do each other favors. I'm just talking favors purely at the level of, I need this and that. Could you please, do you have this sum of money, 20 rand? I want to buy sugar or whatever else. So, speaking for myself, I never understood it to be a rebuff. I say it is, in fact, not a rebuff. I also don't want to impute unbecoming conduct on her part as if she is a money monger. I mention this purely at the level of us playing. Remember, flirtation is playing. It has got this jovial mood about things. It has got idioms. It has got words that must be explained by whoever is uttering them, as we will see as we move along. That is my answer to the question whether that constituted a rebuff. I never understood the expert to have been saying it was a rebuff. I understood her to be saying it could be seen that way. I understand also what the complainant said, which is that, well, I knew if I mention money, he's going to run away, but it's not a rebuff. Not all men will run away anyway. I'm not claiming expertise on this, but I'm just using my logic and common sense.
Yeah, fly along.
Thank you. Chairperson, then we have this earth-shattering statement, Yazbam Nakandi Funa Imali Uzandinika. So be it. Grant her that. 1170, truth, life is not about money. And then I say, hey, It's taking a bit longer. Maybe you are still taking some photos, which I deleted, but which she uplifted. But she is laughing, and she has got this emoji that I have explained earlier on. Well, I said, well, I don't know. And then 35%, ayini sundiqhatha. This is where I say, also, this is not a rebuff. I'm still using it in the context of what I said earlier on, which is that, come on, don't cheat me. Don't cheat on me. When somebody says sundiqhatha, it means don't cheat on me. But once again, if you look at the
Before
context,
you are misunderstood. The word cheating in English and Western
yeah,
notions,
it can be a
Could you
bit
please
rough.
explain what?
Yeah.
'Cause
Ayini sundiqhatha, don't be tricky. Maybe I could use that. Sundiqhatha, I don't know whether to say don't pull wool over my face or something like that, but it relates to me allocating her 35%. In this interaction, which is flirtatious, I'm granting you 35%, you are left with 65%, and so on and so forth. But it's not a
where are
rebuff.
we?
We are at page 1171. Sorry, Chairperson. Ayini sundiqhatha, and there I say,
JP, can I ask you again? I know I've been asking you a bit slow. Mention the time so that.
thank you, sorry for moving fast. Chairperson, we're at page 1171. Ayini, laughingly, sundiqhatha. Hey, banna, or hey, chini madod, or something like hey, ake. Those are all terms that we could use as Xhosa speaking persons.
Can I hear maybe the for the benefit of everyone, the interpreter tell us that?
You want a different one, Council?
No, I want the one from an expert, not him.
Ayini falls under the list of exclamations. Yeah, okay. Kini, haibo, you. There's quite a few.
Meaning,
They all express a sense of excitement over whatever you've heard, or a bit of shock mixed with a bit of excitement in between. It's never really on the negative. It's one that might be a bit heavier if someone has passed on and you receive the news to say so and so had passed on, then you will hear them saying, yeah, okay. That's now a sense of grief that was unexpectable. That is something that was not expected. That's how I would separate it from excitement and as well as receiver of bad news. I hope I'm making sense, Chair.
Thank you.
Thank you, Chairperson. Thank you, Council. I won't distance myself from the articulation by the interpreter. To simply say ayini is plural, ayi, and terminologically, it doesn't mean no. It's not a rebuff, as has been articulated by the interpreter. It's as if you are addressing many people when you say ayini. Then unamaqhinga, and then at 1172, she says, but surely this is far from half of it all. Sorry, that's me talking. This is far from half of it all. Actually, it's 70%.
Repeat again where we are.
1172. Sorry,
and
Council. 1172, Chairperson and honorable members. Then I say
The time?
the time is 21:26.
Thank you.
I hate to be wiser after the event, but I can't help but believe, because I don't want to be artificial when I testify and be somebody who reconstructs a scene. But if I say actually it's 70% when adding the other one, so surely in my view, there were about 2 pictures that had been sent. I've demonstrated that one was sent. The trace of that one having been sent was deleted, but fortunately I commented on it. It's not a status picture. Then follows when I say the other one was a non-starter and you know it. This is me interacting with her more in relation to the pictures. Then she says, Aibo, Jesu. Now, once again,
What did you mean, JP?
when I said what?
The other one was a non-starter.
I may have been expressing dissatisfaction with a picture, maybe that was uploaded from her status and sent to me, because I may have been requiring special attention where one sends me a picture and I send her a picture.
Okay.
Remember, Chairperson, through you, Council, I will try my best not to reconstruct. I will try myself to be as sincere as possible, because this happened a long time ago. And as I said earlier on, but for this which was uplifted by Mr. Mola, I would have been at a loss, as I did when I tried responding to the complaint itself. So that's a mere exclamation. And then I send her some picture. The two of us converge insofar as we say there's nothing peculiar about it. And then she laughs at it. Maybe it was somebody who was doing a dance. I don't know.
Where are you now?
I'm at page 1173 at 2133. Then that is laughed at 2141 by her. Then I say, Bendilinde wena ngengoma. Bendilinde wena ngengoma. Now, stemming from a Xhosa idiom, umfundisi ulindwa ngengoma. But I would like to defer to the translator.
Bendilinde wena ngengoma. The translation to that, Chair, would be, I was waiting on you through a song.
Sorry.
And when we speak of umfundisi ulindwa ngengoma, when everybody else is waiting for the pastor in a church, we sing while we're waiting for the pastor.
So, JP, what was your understanding of what you were saying?
In other words, when I sent her this picture, I was saying, don't ever think that I've forgotten your pledge that you will exchange pictures with me. So I'm just saying, well, in the interim, there's something that we can play with. And then I transmitted that picture. In other words, in the interim, there's something that we can chat about or laugh about. Then, indeed, at 2141, she laughs. And then I say at 2142, at 2143, there's that laughing emoji with tongue sticking out. I sort of reciprocate, save that my emojis are slightly different, but it's somebody with tongue sticking out, laughing. And then at 2153, I realize that she might be asleep. Then I say, shame, ulele, shame, you must be asleep. Then she responds, no, andikalali, salungisa for tomorrow. I'm preparing for tomorrow, 2208. So if you drop somebody something that says shame, ulele, surely if they are asleep, they are asleep. If they are not asleep, they may do something about it. They may not, depending on what it is about.
There is a point at which here the expert said you are persisting. Your conduct here, your request, you are persistent, and that the expert frowns upon as you disregarding the possibility that the person is not coming out clear.
Well, that must be looked at against the word "and it." Remember, I said, even if she had not said "and it," persistency within the context of our culture, there's nothing bad with that. I'm just talking persistence in general terms. Until somebody that is persisted with or whose interaction is persisted with then in that scenario, I would simply say you can read the room when they don't respond for some time, or simply disappear and say nothing beyond a day or 2 or 3. So persistence in and by itself is the understanding of the expert speaking from her perspective. And speaking from my perspective, I see laughing emojis. I see these emojis that demonstrate to me that everybody was happy about what was happening.
Thank you.
I have not come across a rebuff. We're at 1174.
Oh, yes.
Then I say, remember to delete, please. Obviously, whatever you talk about, it's best to delete and start a new day, because you don't know who is going to access your phone and so on. But then she
Why
says,
did you say this, JP? Let's tease that a bit. Why did you say this?
say
Why
what?
delete? Why did you ask for her to delete?
Well, basically, it's because I did not move from the premise that somebody else might not access her phone or might not access my phone and be privy to this type of interaction. I've already addressed myself to a chat between two consenting adults, which is meant to be a chat between the two of them. The public ends up being privy to it. It's quite an embarrassing thing. And it may not have to do with flirtation only. I'm talking to people under this roof and say, you know, whatever you talk about with somebody else, you may not like party number 3 to know about it. It need not be flirtation. So her response at 22:24, I'm still at 11:74, is I have long time. And I asked, long time for what? And then I reiterate, when this bout of conversation is over, please delete. And then I delete all text current phone. I delete all text current phone I'm using. That is still at page 1174. But it comes out clearly at 1175, at 22:25. I delete all text current phone I'm using, doesn't have space. I don't have memory card. There's no need to worry. This is a complainant talking to me.
What did you understand that to mean?
I understood that there was no unhappiness whatsoever in our interaction. And in fact, she says, I don't have to worry. It gave me this assurance that this is going to be something between the two of us, talking about it from time to time. And I never saw this day coming. She says, need not to worry. At 22:25, then at 22:26, I say, okay, cool. Then I engage in this arithmetical exercise. 50 minus 20 equal to what? This is a question posed by me. She responds by saying, well, 100%, I've done everything. I say, no, you are wrong, and I laugh. And then I say, I give up on your arithmetical shortcomings. That's at 1176. At 22:30, she says, bear with me. When somebody says, bear with me, it simply means nyamezela. Bear patiently. Be patient. That's how I understood it, within the context that we're talking about exchange of pictures here. I've already mentioned that she had shared a picture, 1 or 2 at this point. I may not have been satisfied. We were flirting, we were laughing it, we were playing along.
I know I'm being pedantic, JP, but someone reading that, what was your understanding of that? Bear with me.
I understand that
I'm being pedantic about spelling. What
yes,
did
there's
it
a
mean?
problem about spelling,
Okay.
but I've read something into it, which is BEAR. Bear with me.
Okay.
Be patient with me. Nyamezela in Sikhos.
Thank you.
Then I laugh and then I say, well, I've heard you. And then I share a picture, obviously a funny picture at 22:37. Then in response, page 1177, What is his problem? Maybe akakwazi. It could have been somebody trying to do things, be it dancing or whatever, but who may not have been that skilled in it. So she says, maybe this person can't do it properly, but I already commented that this is funny. I can't remember what it was about. I don't want to reconstruct, but it is something that both of us laughed away. Then there is this emoji, 23:35 from me, monkey closing eyes. We said 8 and 9 June, so I'm at 9 June. I had thought uzakwehlela. So clearly, he must have sent me a picture. When I say I had thought uzakwehlela, I would like to compare it with what I said on another occasion. Let's go to page 1274 as I try to explain what I was saying here. 1274. At page 1274, something we will deal with in another context in due course, you will see if ubunokwehlela, if you were to scroll down, kuvele ubuso. In other words, when in a phone, you scroll down, when you do this, you scroll down, it means the upper portion of somebody shows. In other words, I'm saying kuvele ubuso. It might be that I had been sent a picture that was not clear as to who the person really was. But I can only say, when I say scroll down, it could be that the picture that had been sent did not exactly show a face. So that's why I said I thought it was a question.
Which is page what?
This is at page 1177 and page 1178, within the context that of saying scroll down. Then that is 9 June,
the time.
1178.
Thank you.
1178. Inoba uvuke late. So when I said I thought uzakwehlela, it related to what I had said very early in the morning on 9 June. I can't think of anything other than that. I must have been sent a picture. And when I said inoba uzakwehlela, I meant just that I thought you would show it in full perspective so that I see who this person is. But once again, this is me talking at this point in time. And it doesn't make sense for me when I say or comment and say, I thought uzakwehlela. It must have related to a picture that I had been sent. But I don't want to make it bigger than that. I say it might have related.
JP, let's make it bigger than that. Let's see. What do you say to an interpretation if one interpreted that to mean you wanted her to show the lower part of her body?
There's nothing bad with that. Even if their interpretation, if somebody gives you a passport size photo,
Yes.
when you say inoba uzakwehlela, just give me a full view of your body.
Yes. I was just
Part of-
asking you that so that we leave nothing
Yes,
that is
yes.
not.
I appreciate that, counsel, because there are many ways of looking at it. But as I say, if inoba uzakwehlela, which means if you show me a half picture showing your upper body, basically when you say inoba uzakwehlela, a full view of your picture,
Thank you.
you would have seen I did something like this.
I can see. It's just.
Then 10 past 10 Cwaka. The first chat was at 5:33 Cwaka. Inoba uvuke late. I say, hey, maybe you woke up late. Then morning judge,
What
I
did
woke
you
up
mean? Can we go back to
1178. Cwaka means silence.
That's what you meant, but let me
Yes,
ask.
I meant exactly that.
It's exactly that, Council. It's
Thank you.
silence, Cwaka.
And then I say, inoba uvuke late, realizing that our chats were deep into the night. Maybe she woke up late, I didn't know, but I then expressed myself the way I did. She says, morning, Judge. I woke up early but got busy. 10, 11. Then, because it was during working hours already, I said, let's chat much later. And then I also added, if circumstances permit, and indeed she says still busy at work, and then I say, okay, shame, inoba nilele, that is much later on that day. Then that takes us. Your mic may not be.
I'm saying let's deal with this because it's a point that was raised that the person is telling you that she is busy. Therefore, you must read between the lines. It was interpreted as a rebuff.
When somebody says they are still busy,
Yes.
I also understood it to be during working hours. And that is why I said we'll chat much later. Then she says still busy at work. She says that at 17:04. You must remember at 11:10 during the day, I said, well, we'll chat much later. And I qualified it and said, if circumstances permit. I said that at 17:04. As a follow-up to what I said at 11:10.
What do you say to the interpretation that this, when someone says I'm still busy, they are telling you don't bother them again?
That was not my understanding.
Okay.
Then I said, okay, shame noba nilele 2017, and that was the last of it on that day. Then the next one is on the 10th, and then uniform free day, that is her status picture that I'm commenting on, which you will see differs from the picture that she sent to me. It differs from the picture that she sent to me, which had the word you only, not status. So I commented on that. I was impressed with how she was dressed. That's why I said shoe with hands lifted up. She responds to that with a winking emoji and she laughs. I also laugh likewise.
What time is that?
I'm at page 79, at 20:04 and 2015 respectively. It's 11:79, 20:04 and 2015. And then I also reciprocate by laughing. That was the last chat on 10 June 21:25. Then 15 June, we wake up to a status where she says, "Ndisemhle ekujikeni kwelanga." The laughing emoji was not necessarily meant to laugh at what she was saying necessarily, but I just had the feeling that it was a bit immodest for one to say ndimhle and saying that in a status picture. But it's just a comment there, laughing. I found it to be a bit immodest, but that's neither here nor there.
May I just ask a question? May I just ask a question for clarity? This status picture, was it sent to you or did you see it on her status when you opened it?
When I opened her status, I saw that picture and commented on it. And whilst at it, Honorable Member, we can go back now at this point. Go back to that picture about which I made moment. Honorable Member, you will see the difference between these two pictures. The one at 1166 only has you photo, 1166 at the bottom, or 1166 at the bottom or 1167 on the top. So there's a difference between that one. I'm commenting there on a picture that she sent to me. So there's a difference. It says you, it's a photo that she sent to me. Whereas what the Honorable Member is pointing out is that this was a status picture and I commented on it. So it was not necessarily meant for me, but it was her status picture. That goes for what is at 20:04 and what is at 20:02 on the 15th of June. Motion court was getting on my nerves. I knocked off not so long ago, 20:02. Why did it take that long? Ma'am, we had an agent that took forever, involving what? Then the chat goes on 1180, 1181, and then we go to 1182. So up to this point, Council, I've not come across a rebuff. We are now at 1181. And I did not have to take the tribunal through all those charts that related to what was happening in court and so on and so, as a matter of interest on my part. Then there's 16 June. 16 June starts from, the real crux of it starts at 1188. Maybe it's a subject that I must delve into right away. Because 16 June, I see something on her status on 16 June, and then I comment, whoa, 1648 in the afternoon. Then she says it's a stress reliever and easy.
Sorry, where are we now?
1182. There's less and less of pictures now at this point, and at this point in time, there is less about pictures being exchanged between the two of us, but it's more another theme. Not that we will not be talking about pictures in due course. So 16 June, 1182, whoa, stress reliever, I say, and easy. I suspect that it had to do with, what do they call that thing, zip something, where people are on heights. But all I was trying to say is,
Sarah calls it a zip line.
zip line. I suspect it had to do, it was a picture that had to do with that. She says to me it's a stress reliever, and then I say and easy. Seated where I am now, I know that I have got height phobia. So I was saying and easy. And easy is a relatively new term where one says, no, that's not for me, and easy.
Oh, no, I'm not going to do that. It's basically a slang.
Then she laughs, and then I ask Stress Andoni, you? And then she says, Ju, I act strong. What is the stress for? What is it that causes stress?
Okay.
Then the response at 1701, True, I act strong, but am in shreds. In all honesty, after Ndithukwe court manager, I'm literally pushing myself, otherwise andindim. So the court manager topic rears its head. All I can say is, in response to that, I adopted the stance that insofar as there's this apparent dispute between the complainant and the court manager, as for me, they are just people that I work with, call them my kids, as I illustrate there. When I say, well, in some way I say, I'm not going to say anything, but let's read it. So I respond at 1705, say whatever you want to about me, it never changes the real me, so I'm not in that slot. Nonga andithandiyo umuntu ndiyamsizela because I love everybody. As for the subject you are introducing, allow me to say only maturity will triumph. And you know exactly what I'm talking about when I say I love even those who pretend to like me. So it was more a talk based on what she was saying, introducing this topic about the dispute between herself and the court manager. I elected to exit insofar as I'm being dragged into this dispute. This is how I see it when I read here. Then she says, well said, your words after your meeting with practitioners still echoes my swing. That continues, 1184, there's nothing of moment. 1185, there's nothing of moment, at least as far as I'm concerned. 1186, we still talk about relations or reconciliation within the context of one who is having bad blood with another. Then I talk about the ability not to hate others. And then I also say, once you smile, it irritates the enemy, but the positive attitude fills the room. Uyayazi ke le nto ndithetha ngayo. In other words, I'm saying, you know what I'm talking about. And then she says, you are an inspiration. I don't want to blow that out of proportion, but this is a response to the sort of counsel that I was giving her. You are an inspiration.
Give us the time. Of
The
that.
time is 1709
Thank you.
at 1186, at page 1186. And the thing is, I like everyone, Pakulachini. I mean, court staff. I spend sleepless nights if I end up reprimanding somebody and have to mete out tough love. She comments to that. There's nothing of moment, even at page 1187, save that I say, as for this dispute, it benumbs me. It is like my natural offspring are not seeing eye to eye. In other words, that's a metaphor. It's a manner of speaking, where the two persons who are at loggerheads with one another are known to you. And the one is dragging you to his or her side. And you keep saying, look, as far as I'm concerned, you know, this to me is like siblings, offspring, in other words, offspring, not seeing eye to eye. Once again, I say, Chairperson, nothing much hinges on that. Exactly. And then 1188, invitation for a hug. She says, you are disciplined. Once you have a principle, you'll be like an eagle. At 1715 at page 1188. That is what the complainant said. And then the tone changes. I say dancing and hug. The latter is exciting. Mhlawumbi kungangcono. She says it would be better if I were to be given a hug.
Where is that now?
That is at page 1189 on top at 1716. Chairperson, maybe let me at the outset place it on record that I have elected not to approach things as if I'm suffering from selective amnesia. I am not going to proceed with this matter by looking at one side. I'm going to try my best to demonstrate that this is what she said, this is what I said. I'm not going to adopt an approach whereby one chooses only what I said and not what was said by the complainant. It may be time consuming, but I have to do it. So she says, I would choose a hug. And then I say, as long as it won't generate warmth. Then she asks laughingly, how is that possible? And then I say it could. Then I
Just
say,
hold
well,
it there, JP.
1189.
Yes, give us the time, but what did you mean? What did you understand that to mean?
I was saying, you know, in the case of two persons who are engaged in a flirtatious interaction and they hug one another, it may generate warmth.
And what did you mean? You'll forgive me, JP, so that we do exactly what you said, which is about sincere, about each point, even if
Yes.
it's embarrassing. What did you mean?
I was simply saying, hey, you want a hug as long as it won't generate warmth. That is what I meant in the context of flirtation.
Thank you.
How is that possible? Then I say it could. Monkey covering eyes. Then it depends. Then she says at 1721, well, we will see. Then to ascertain or check the room, I then say, please declare up front, it's not a shame.
What did you want her to declare?
Remember, I was saying if it won't generate warmth. So let's rather not do something, especially within this context, that may generate warmth. That's what I was trying to say. Then when I say to her, please declare up front, it's not a shame when you say to me, hey, you know what? A hug can trigger me into something. She says some things are better when not said, sawubona.
Can you tell us where we are now?
I'm at 1190,
Time?
1723.
Thank you.
And this is the complainant talking, saying, when I say declare upfront, some things are better when not said, sawubona. I would elect to say nothing. Let's see when it happens. Then I say, can't it helps? Then I ask, are you quick to melt? Talk to me. Then she says, it depends.
Let's get
At
there.
17:30.
Let's get to what that means, because it's been the subject of discussion. As embarrassing as it may be, what did you mean?
I was saying, well, you see, if we meet and hug one another, declare upfront, maybe really it might cause you to melt and things might end up taking a direction.
Let's unpack the word melt. What did you mean?
Melt is a sensual term.
Yes. Thank you.
She
Well, I
says
didn't
it
hear that.
depends.
Could you please repeat for the chairperson what
It
do
is
you
a
mean?
sensual term.
Sensual.
SENS SUAL. Sensual.
Well, JP, I want you to explain it so that no one thinks you are closing over things you meant. Could you please explain further?
Explain about melting.
Yes.
Yes, melting simply means, when I say sensual, one thing may lead to the other within the context of a male and female hugging one another closely,
Yes.
chest to chest type of hugging.
I'm not suggesting an answer to you. I'm just trying to say, would it be the same as saying this is sexual in character?
That's why I said sensual, because I elected to go for a more modest word, but I don't mind your suggestion.
Thank you, JP. You may proceed.
Depends on what. Then she says, no, I'm cooking on the side. I am cooking on the side. Now, when she says no, she is responding to usacinga. Are you still processing this in your mind? She says, no, I'm cooking on the side.
What did you understand that to mean? Because we know
I
now-
understood her to be saying, it's not that I'm still processing it in my mind. I'm actually cooking. In other words, she's saying, no, andicingi, I am not thinking about it. I'm not processing this thing about warmth and that it is likely to generate. Remember, she has said some things are better when not said, sawubona. Some things it's better not to even talk about them. Some things are better done than said.
And your understanding
That was my understanding.
Yes, and your understanding of that, if she says she meant cooking literally.
Well, in this instance, Chairperson, where I say, are you still thinking about it? She says, no, I'm cooking on the side. In other words, I understood her to be engaged in some form of cooking at home. Admittedly, I don't want to read much into it.
Okay, you may proceed.
Then that is repeated at 1191. Then I still ask, what does this about? You see, where I say it depends on what? How is it possible as long as it doesn't generate warmth? Remember, she's talking about what she was doing at the particular point in time. The no in that instance is not a rebuff. It is simply to say, no, 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 I'm not processing anything, or I'm not talking about that. I'm cooking on the side. But then I say, it depends on what? She responds at 1731, it depends on oven temperature. Then that becomes sensual from her side.
Why do you say so?
Because the background here is, as long as it won't generate warmth, how is that possible? It could. And then I say, it depends. Then she says, we'll see. And then I say, come up clearly. She says, some things are better when not said, sawubona. It's better not to talk about it, we will see. And then poof.
I'll request you again, JP, to be slow. I know
At page 1191, oven temperature. That is sensual. Melting depends on oven temperature. That was my understanding. Melting, which I've already addressed,
Yes.
depends on oven temperature. If somebody says, well, I'm hot, depends on oven temperature. Not oven temperature as in cooking this time, but remember, no, I'm cooking on the side. I don't know, this person who was counting 12 knows. Maybe she counted this as well, or he counted this, I don't know, but I'm just mentioning it. So in the context in which we were discussing, melting depends on oven temperature. That is, it depends on how warm the person is. That was my understanding. Okay, oven temperature, and then I laugh at that. And then she responds with a laughing emoji. Sorry, firstly, that monkey covering her eyes. This, in my view, did not convey literally temperature now at this point. Where she says oven temperature, the pendulum had swung a bit. Now we're being sensual here. Sorry, I will always use sensual.
That's fine.
Then I say, I hear you when she says oven temperature. Melting depends on oven temperature. Then I hear you. Then I ask, if you happen to have melted, step one. Then she says it would mean the marinade worked before the heat. That's highly sensual. Not just flirtatious, it's highly sexual.
Because
She says it would mean that if we had hugged one another and we melted, then something must happen flowing from that. It would mean the marinade worked before the heat. It would mean the hugging would have had an impact on us, joining our bodies, hugging one another.
Thank you, JP.
Then I say, well, that's true. So this
We
thing
are-
about marinade.
What page are
and
we now?
I'm at page 1191. Then I'm moving across to 1192.
Thank you.
Then she says, well, I said 1733. If you happen to have melted, what is step one? 1733. She says hi and she laughs. And I say, this is hi, this is no. And she laughs. This hi can hardly denote a rebuff, in my view, especially if one has recourse to the laughing faces and what had been discussed previously. Because she is the one who comes with the notion of a marinade working before the heat, not me. So it seems I had said, well, Ndimamele. Then she says, she says, well, I'll keep.
That's meaning?
That's at 1734. When I say Ndimamele, I'm listening to what you are saying. This is me talking, which would have been deleted. And then
I see interpreter is nodding.
Ndimamele, I am
I'm
listening.
listening.
Yeah.
I'm still here, JP.
Yeah. Thank you.
It means that, yes,
Okay.
I'm listening.
All right. Thank you. 1734, she footnotes something that I had said, Ndimamele, I am listening. And then this is me saying, Ndimamele, I'm listening to what you are saying. Then we've got those three things zipping their mouth, followed at 1748 by me laughing, saying, Teta wetu, talk to me about it. This in my view is still a light moment. I'm not saying anything than simply saying, I am listening. There is nothing that I necessarily conveyed to her. I believe this was a light moment when I say, Teta wetu, say something. And then she laughs at that. Then she continues, Qala undixelele ukuba, lo step one that you are talking about. Before I say anything, tell me what this step one that you are talking about. Now, this talk is sexual.
Just a minute. I don't know. I thought we said we stop at 4 o'clock. Would that be fine with everybody if we stopped here?
Oh, yes, JP, we wouldn't stop you from stopping, but you had said 4:30, but I would encourage your interpretation.
Oh, well, hang on. Did we say 4:30? Did
Yes,
you agree on 4:30? Well, then we must proceed.
I think that's what the chair said, but
Well,
you're allowed to change your
I
mind.
mentioned the 4 o'clock by accident. So we proceed until 4:30.
Thank you, Chair.
Chair, until 14:30?
4:30.
Sorry, 4:30.
We still have 25 minutes.
Yes. Qala undixelele ukuba lo step 1 that you are talking about. Position 1, then I try to come out clearer. And this is one of those embarrassing charts on my part, by the way.
Can you explain that? Are we on that embarrassing part about sex positions?
We are getting there.
Thank you.
So she says to me, position 1 being what? Come on, stop riddles. Khawuthethe le nto ufuna uyithetha. Uyeke izafobe.
Let's hear from the
It means get to the point and stop speaking in riddles.
Did you read any annoyance in this or in the answers you're getting or instructions you're getting so far?
Not at all. This is somebody playing along, in my view.
Thank you.
So somewhere there's something about assuming melting occurs evenly. Then I say that is not disputed. She says that is not disputed. In other words, if we were both to melt, there is a danger in that. One thing can lead to the other. Then
What
says,
time are we now?
we are at 1753. That is
Okay.
not disputed. So at page 1193, she asks me, hey, we've been talking about these things. Are you deleting these things that we are talking about? This is the complainant at 1755. In relation to position 1 of action coming from me, but at 1755, she's saying, are you deleting? So both parties meant to keep these charts clandestinely as far as I was concerned. And she then invites me to explain everything has a name. This is said at 1755 at page 1194.
And what did you understand by this?
She was leading me on
Okay.
regarding being head to the topic. And then when I say and you, I was checking whether she does delete. And I was assured of secrecy. She asked me, are you deleting these things? Remember, these things relate to two people and what we are talking about is sensual. Then she also checks from my side, I'm asking her, are you deleting? And then she responds at 1757 at page 1194. I am deleting because my phone space isn't that big, that's one. 2, I don't want these to be seen. Same here. I don't want this to be seen. Kanjani, asazi, but it's the best way. In other words, I don't want people to have recourse to what we are talking about, especially the point that it had reached in relation to the sensual talks that we were having. So she is asking me, are you deleting? And I obviously said, yes, I do delete. I had said that earlier on. Within that space, she's also saying, when you talk about position 1 of action, everything has a name. Spell it out.
What did you think she wanted you to spell out?
Spell out this position 1 thing.
Okay.
So I'm asking her whether she does delete. She responds at 1757 that she does delete. Firstly, for space reasons. Secondly, I don't want this to be seen. I trusted her. I trusted her bona fides on this. Then I say, I'm with you there. So the ear is meant to say, well, carry on, let's talk about it.
Did you agree? Were you both in agreement that they have to be deleted? Because
There was that understanding.
You've said that before yourself.
Yes. It's
Okay.
implicit, counsel, from the interaction that we were both of the view that what we were talking about related to two adults who were interacting, and they were on par in their interact. There was nothing unwanted. Certainly not at this point.
Thank you.
But I'm given the assurance that, well, we are deleting. I'm also deleting. I had all the reason to delete. But then she mentions why she deletes. Firstly, to save space. Secondly, you never know, somebody may access your phone. And therefore, I say I'm with you there. Then 1195. Apparently, I had typed.
Just wait for the.
Sorry,
I see the
1195.
pens are still running. Thank you.
1195.
Yes, could I still ask you, JP, to be slow about this and mention a page and a time and slowly read so that notes are taken?
Thank you very much, Council. Sorry, Chairperson and honorable members, for moving swiftly. So we are at 1195. We are talking about positions. We are talking about deleting. We are all of the view that these should be deleted in view of their nature. And at this particular point in time, I would say none between the two saw a day like this coming, purely based on the type of interaction that we were engaged in. Then she says, well, I say whichever position might come first. This is a direct question. And then I believe the parties knew exactly what they were talking about. She then says, I will go with whichever, in other words, position. But there's a word I like, surprise. That is at 1816.
What is your understanding of this statement?
She's saying whichever position or sleeping position, for the sake of listeners out there, whichever sleeping position, I'm fine with it. But what I like most is surprise. So that's a pertinent answer on the question about these positions.
Thank you, JP.
This is a talk between two adults. It is wanted. They even talk about deleting what they were talking about, and that is it. It is what it is. Then I probe it further. By the way, I don't agree with the notion that that was a rebuff, that type of answer. That was deep, flirtatious talk. But you cannot have a favorite position purely at the level of naughty talk or chat. I say so in so many words. And then at 23:19.
Sorry, JP. Let me go back. You say it wasn't a rebuff. Another word was used. That actually not another word, another phrase that. But she is not giving you an answer. It means she's deferring.
Chairperson, it can't be so. We are all adults in this room. Somebody saying, well, I'll go with whichever, but what I like most is surprise. I don't think it's available to anyone to pull wool over any other person's face on issues like this. Remember, we are supposed to delete this. There was an implicit understanding between the two of us, and we are here today. But that's just by the way.
Sure. Thank you.
So this whole chat ends at 23:19. When I say zzz, it is a sign that I am going to bed. Ndiyozela, ndiyalala. It is not checking whether the other person is still awake or asleep. It's simply saying, I'm retiring to bed now. That is at 23:19. That is on the 16th of June. So we are now going for 17 June 2021 at page 1196. This is where we get to something that's related to K8. So 17 June, remember the previous day was a public holiday. 17 June, kuthiwa anizikhweli. In a way, it means, I understand people are not going to work, anizikhweli. It relates to e-taxi that people board when they go to work. Maybe I'll defer to superior wisdom.
Anizikhweli, meaning we are not going to work.
Then she then says, I'm at work, mna. I've got 2 urgent applications. She says that at 1953. So the first chart is at 1938, and then at 1953 she responds. And then the meme is about saying, it's a way of suggesting that, you must be working very hard. I can't explain it beyond that. Sometimes you send these memes, you realize it might mean something else, which you may not have intended. But it was a way of saying yo, because below that I say yo.
And what time is that, JP?
This is 1954.
Thank you.
And then there's a video that I sent at 1954. It probably related to what was happening in the area. Then she says, Beku rough, and then I exclaim. Then she says, even tomorrow they are continuing. I understand this is a strike. And then 1197, near Nakuba a court as usual, generally. She answers, yes, JP. Okay. Then I'm at 1194, at 2006. It's less of a threat to our operations. I'm asking. We are a court. The fact that what is happening around.
Sorry, where are you?
Page 1197, Chairperson. 1197. At 1958, she says, even tomorrow they are continuing. Near Nakuba a court as usual, generally. 2004, she says, yes, JP. And then I say, okay. Then it's less of a threat to our operations. I'm asking, is the type of strike that is embarked upon a threat to court's operation? She says, at least today they didn't come near the court. We don't know about tomorrow. And then I said, Ndivile, 2007, chat later, still busy at work. And I confirm, I say yes later. And then at 2114, I indicate that I'm retiring to bed. 2114. I must say, even in hindsight, I was not gagging her necessarily. I was just indicating that I'm retiring to bed. It was 2114. There was no intention to gag her. Then she, at 2117, just got home. So I must have had a message coming in. And then when I looked at it, it said, just got home at 9:15 in the evening. And then I say, yo, that's an exclamation. We'll start again.
Meaning?
What?
The exclamation. What did you mean?
No, when somebody says, I'm only returning back now, you exclaim, it's a neutral exclamation, basically, that, yo, you work until this late, and that's it.
Thank you.
Yes, thank you. Then I exclaim, yo, we'll start again at 5 in the morning. This is what she says. Then I ask 1198, Chairperson, page 2124. I asked at 2124, what are we going to be starting? She says, urgent application. Then she says, papers went in order, so we had to adjourn for 5. This is 0500. What? I'm asking. Makanda strike. Oh, now I understand. Besindawoni last night, we were warming up. Now I revisit what we had been talking about. So much for work-related stuff. This is the complainant and I, flirting. We had been talking sensual stuff. At no point was there an indication of a rebuff or anything like that. So I was free to say, Besindawoni kanene, where were we last night? Resumption of a sensual talk. I tried my best to be modest. Besindawoni last night, we were warming up. Then she says, Haibo, usabuyela apo, with these monkey emojis. Now
JP,
I'm saying,
just on that point.
2127.
Yes, what do you say to an interpretation that by asking that question, she's rebuffing you?
I am saying one must remember how deep.
Can I ask the interpreter first to tell us what?
Okay.
Aibo sabuyela
Isata
apho.
aibo sabuyela apho. Once again, we have a word aibo, which does not necessarily mean no in this context, but more of an expression of surprise. Are we still going back to that?
Thank you.
Aibo sisabuyela apho.
Yes, JP, what do you say to someone who says that is a rebuff?
I say it is indeed an expression of surprise, but with flirtatious emojis as far as that I was concerned, at least according to me and given the background of what we were talking about. This is a person that interacted with me about sleeping positions and all that the previous night. There was something about surprise. There were idioms, there were riddles and all that.
Yes.
I then say, purely because we are about to land. Then she says, yazi ba exhaustion is extreme. Senzo lala kuba will wake up usalele wena. You must know.
Can I ask you about
21-28.
about purely because we're about to land?
I was just saying what we were discussing previously about those positions, we were just about to round off because she had said, I like surprise. And I was insisting, man, you can't not have a position that you like. You know.
Thank you, JP.
Thank you. So then, yes, but exhaustion is extreme. Senzo lala kuba I will wake up usalele wena. You must know that exhaustion is extreme. I'm about to sleep because I'll wake up very early when you will still be asleep. This is said at 21-28.
Thank you.
It's the correct interpretation
Thank you.
or slash translation.
So that is repeated by the system at 1199, page 1199 at the top. When I say purely because we are about to land, she laughs with four laughing face emojis. In response to purely we are about to land, all she does is to laugh. There's no indication of unhappiness with the revisitation of the subject. A subject that is deep in terms of idioms and the riddles that we were engaged in when we were talking about it. But for her part, she had come out clearly. I like surprises, or I like surprise.
Thank you, JP.
Sorry. With regard to the message 21-28 on page 1198,
Which is repeated at 1199
yeah,
on the top.
but my note is on 1198. She was asked, why did you answer this way? And she said, I was being sarcastic and wanted him to leave me alone.
Yes.
I did not read that sarcasm, or I did not understand to be any sarcasm in that. This is based on the level of depth of what had been discussed previously, partly. It was also based on the fact that this flirtatious relationship had reached a point where we were almost calling a spade and talking about things we were not actually engaging in physically, but in this playful scenario of flirting, because flirting is basically not doing the actual thing, but talking about things, so to speak. So I did not understand that sarcasm in the circumstances and the context of what I have just said. Was Chairperson purely because we were about to land, or exhaustion?
It looks like as though
Is the chairperson relating what he is saying to Yazba exhaustion is extreme? Sentizolala kuba I will wake up usalele wena. Now let's deal with that at page 1199. It's clearer because it's at the top. You must know that exhaustion is extreme. In other words, I'm very tired. I'm about to sleep and I will wake up early when you will still be asleep. This is what she's saying to me.
yes, it was in relation to that.
Thank you, Chairperson.
But you have answered.
Yes. So when she says, when I say purely because we are about to land, she laughs at that. This is signified by what is set out at 21-28. Now she says, I will wake up at 2 usalele wena. In other words, I will wake up very early usalele whilst you will still be asleep. Then I was quick to negate that. No, I'm also waking up at 2 a.m. to write a judgment. This is what I was saying to her in response. I said that at 2128, Chairperson and honorable members,
On page?
page 1199. I'm
JP,
waking up.
I'll remind you again, just slow and give us time.
Thank you. At page 1199, this is where we are. We are at 2128, Chairperson. I am saying in response to what she said to me, when I wake up early, you will still be asleep. I'm saying, no, I'm waking up at 2 a.m. to write a judgment. That was not a fallacy. I've checked and found that at that particular point in time, I was busy with a judgment that was highly exercising my mind, and it's Minister of Police versus Sheriff Mtata and another, reported at 2022, Volume 1, South African Law Reports, at page 229, a judgment of the Eastern Cape local division in Umtata. So that does appear on my CV. I did mention that from time to time, I might refer to the CV insofar as it may be relevant to what we are about. So the CV is in that volume that I was talking about, and I have marked that judgment. It's judgment number 5, penned as Judge President of the judgments that are reported. So whilst in all, as a judge, I penned 9 plus 13, which is 22, plus 6, which is 28. Those are the judgments that I've written as a judge. So when I say I will be waking up at 2 a.m. to write a judgment, I meant exactly that. That judgment was handed down within 2 months. And if my memory serves me well, I was about to go on leave for a month, a week from that point, and indeed I was writing this judgment. Chairperson, I pause here to mention one thing, which is this, that maybe a word might go out there that this is a man who is busy chatting. What is he doing? Is he doing his work? I love my work. I'm not for mediocrity, and I will say that again if I've got to say it. That judgment is a reported judgment. Chairperson, members of the tribunal, the panel, they know that judgments that are reported are judgments that really deserve of being reported. So I referred to my CV, and I did indicate at some point that somebody might say, here is this man chatting. Does he do his work? I love my work. I miss it.
Chair, can I indicate that we're about to get into the date of 18 June, and it's a separate theme, sub-theme, so to speak. May I suggest that we adjourn at this point so that we start there tomorrow morning?
Yes. We'll adjourn until tomorrow, 9:30.